Mr. Gould, I believe you sent an email yesterday uh, informing parties that you were waiving cross
Madam Hearing Examiner,
of the staff witnesses.
yes, Madam Hearing Examiner, I sent that to you and Mr. Schaefer. I also sent it to the Staff Council. I didn't send it to the Joint Applicants Council. So I assume that we would just announce that first thing this morning.
Okay. Well, then I will let you do that.
Okay. We are waiving cross on the staff witnesses that we had
Not right
reserved.
now. We're not on the
Okay,
record yet.
sure. I'm sorry. Okay,
No, we
so I
still
have
have 6.
6
You're
minutes.
raring to go. We are live streaming on YouTube, just to let everybody know. But we are not on the record yet. I have that we have 5 more minutes.
I finally got a good night's
So
sleep, so
excellent. I'm glad one of us did. Um, I seem to be dreaming. If I'm not working, I'm dreaming about working. And I was dreaming about, oh, got to talk about those bench requests. Oh, need to do this, need to do that. So fun. Okay, well, get that last glass of water or tea or hopefully non-alcoholic beverage. Uh, and we will go live here in 5 minutes. Good morning, Mr. Lee. How are you?
Good
Don't
morning,
see you
Judge.
yet. Do we have a different hat today?
No. Black suit,
No.
black hat.
Black hat. Okay. Awesome. Okay, we have 5 minutes and
I'm ready when you are, Judge.
Very well. Thank you, Mr. Lee. Good morning. We are returning from our recess Friday evening to continue our hearing in case number 24-00266 in the matter of the joint application for approval to acquire New Mexico Gas Company by Saturn Utilities Holdco. My name is Elizabeth Hurst. I'm one of the hearing examiners in this case. Along with me is Patrick Schaefer, who is the other hearing examiner, and our court reporter, Mr. Lee. If you need anything to do with the transcript, you'll need to contact Mr. Lee directly. Per request, I am going to ask for appearances to be made on the record. And I'll just begin with the first box on my screen. Ms. Nanasi. Good morning.
Good morning, everyone. Marielle Nanasi on behalf of New Energy Economy.
Thank you. Mr. Haverly?
Yes, Madam Hearing Examiner, Commissioner Schaefer, Brian Haverly, Tom Domi, and Juliana Hopper on behalf of Amera, Tico Energy, and NMGC. Also with us today is Nicole Strausser, the General Counsel of New Mexico Gas Company.
Thank you very much. Mr. Dubois/Dubois.
Good morning, Your Honor. Will
Good
Dubois.
morning.
We'll go with that today. Dana Hardy and Rick Alvidrez for the BCP applicants.
Very well. Mr. Friedman?
Good morning, Your Honor. Jelani Freeman, representing the federal executive agencies. And I just mentioning that I think I just saw an email that Ms. Lynch is trying to get in to the Zoom.
Thank you, sir. I appreciate that. I hit the admit all once, so now I'm hitting the admit all again. Ms. Lang?
Good morning, Your Honor. Katie Lang on behalf of staff, together with my co-counsels Nicholas Rossi and Ryan Friedman.
Thank you. Mr. Gould?
Madam Hearing Examiner, Mr. Schaefer, Peter Gould on behalf of Anameria. Mr. Young will not be making an appearance today. He's working on other matters in the case.
Thank you. Ms. Beatles?
Good morning, hearing examiners Hurst and Schaefer and colleagues, Sydney Beatles for Western Resource Advocates.
Thank you. Mr. DeSalen?
Good morning, Madam Hearing Examiner and Hearing Examiner Schaefer and everybody else. Charles DeSalen, representing Coalition for Clean Affordable Energy. And also here is my co-counsel Carol Lynch, also representing Coalition for Clean Affordable Energy and Prosperity Works.
Very well. Thank you, sir. I see you, Mr. Harris.
Good morning, Hearing Examiner Hurst, Hearing Examiner Schaefer. This is Brian Harris on behalf of the New Mexico Attorney General, and good morning to all my colleagues.
Good morning. I believe let me know. I believe that's all of our appearances. Very well. As I said, we're resuming our hearing from our Friday recess. One of the procedural matters that I mentioned off the record that I wanted to discuss this morning were the bench requests that hearing examiner Schaefer and I have issued in this case. the first bench request with joint applicants response. Made that bench request on the 3rd. And joint applicants responded on the 4th. And what I asked for them to do was to provide a list of commitments the joint applicants proposed to provide in addition to the commitments proposed in the revised application. And Mr. Bodier and Mr. Shell responded. Anyone object to the admission of the bench request response to the first bench request?
Madam Hearing
Hearing
Examiner,
none,
is
Mr.
is
Gould.
that online someplace? I don't object. I just wanted to have a copy of it.
I will clarify for you, sir.
Okay, thank you.
Mr. Dubois, you're the first name, so I'll ask you. This got filed in the record, didn't it?
Yes, it did, Your Honor.
Thank you.
Filed online, sir. Hearing no objection, the response is admitted. And then the second bench request response. Again, joint applicants' response to the second bench request. That bench request was issued on the 4th and was answered on the 5th. Also, my understanding that got filed in the record. And it is, the bench request was identify in the record any documents that could be considered a board charter or that define or lay out how the NMGC board is required to operate. If these documents cannot be located in the record, please produce them. That response was from Mr. Shell from Gas Company. Any objection to the admission of the second response to the second bench request? Hearing no objection, response to the second bench request is admitted into the record. The other, excuse me, not starting off well with the tickle in the throat. Parties may be relieved. That may mean I talk less. Another procedural issue that was brought up this morning by Mr. Gould had to do with an email. Procedural in nature that was sent by Mr. Gould to hearing examiner Schaefer and I over the weekend. Would you like to address that, Mr. Gould?
Yes, Madam Hearing Examiner. Anna had reserved an hour and 45 minutes for the staff witnesses. And for the sake of the record, those witnesses are Darren Zigage, Mark Tupler, Dr. Larry Blank, Dr. Bryce Sedalis, Naomi Velasquez, and Felicia Hohola. We are waiving that cross time for those witnesses. I did copy that email that I'd sent to you and Hearing Examiner Schaefer to all of the staff council. However, I did neglect to provide it to the other parties.
All right. And I believe also Mr. Gould in area has another procedural issue.
Yes, Madam Hearing Examiner, we would like to enter into the record what was marked for identification on the Dropbox as NM Area Exhibit 45. And additionally,
Identify it,
thank you, Madam Hearing Examiner.
please.
This is the joint applicant's response to Area interrogatory 6-2. The interrogatory generally deals with the cost that the joint applicants are claiming would need to be incurred to migrate NM Gas Company away from the SAP server-based system to the Oracle Cloud system for IT. It was testified to by Peter Tumanello during his examination by me last week.
And it is outside of the folder. Any objection to what's been identified as NM Area 45 and labeled Joint Applicant's Response to New Mexico Affordable Reliable Energy Alliance's sixth set of interrogatories and requests for production of documents. Hearing no
Six-
objection.
Okay. Specifically, Madam Hearing Examiner, not the entire set, but just the response to the question and the response to 6-2.
Mr. Gould, New Mexico Area Exhibit 45 that I have in the Dropbox is only 6.2.
Yes, that's correct. That is the correct exhibit.
Okay.
You had asked
So
us, go ahead.
I'm assuming that in response to the answer, you also want the little chart thing, right?
Absolutely.
Okay. I'll try again. Any objection to what's been identified as NM Area Exhibit number 45, which consists of a question and response to the previously identified interrogatory? Hearing no objection, NM Area 45 is in. Go ahead, Mr. Gould.
Madam Hearing Examiner, how would that be counted in the hearing exhibits? Would that be NM Area Exhibit number 1?
I'm going to leave it as 45.
Okay, that's fine, just as long as I'm keeping it clear. Okay. The second request, we ask the admission into evidence of NM Area Exhibit 46, which is the joint applicant's response to NM Area's interrogatories 4-3 and 4-4. These interrogatories were the subject of Mr. Yar's cross of New Mexico Gas Company's president, Ryan Shell, and were gone through extensively in that cross-examination. And we move now to have those interrogatories and the response moved into the record. I would note for the record that we have attached the affirmation of Ryan Sheld, which was provided with those responses. And as a note, we also attached the affirmation of Mr. Tumanello to the prior exhibit, which you admitted. So with that, if we would ask for the admission of Anamaria Exhibit 46.
Any objection to what's been identified as NM Area 46, the joint applicant's response to the New Mexico Affordable Reliable Energy Alliance's fourth set of interrogatory and request for production of documents, 4-3, 4-4, hearing no objection, NM Area 46 is admitted. Anything further, Mr. Gould?
No, thank you very much, Madam Hearing Examiner.
Thank
I'm
you.
going to put my microphone on mute since I'm not crossing a witness today.
Okay, thank you, sir. All right. At the close of our day, Friday afternoon, evening, I believe there were still some updated exhibits from NEE. Is that correct, Ms. Nanasi?
Yes, Madam Hearing Examiner.
I believe it was NEE Exhibit 7.
Correct. I have sent to Mr. Dome a new version, but I haven't heard from him yet. But I expect I will hear from him, and then we could address it maybe after our first break.
Okay,
It's not working for me again.
very well. I'm hearing you, Mr. Dummett. Very well. And I believe
Madam Hearing Examiner?
that Mr. Dome,
Yes, I'm sorry, ma'am, the technical difficulties again. We have reviewed what Ms. Nanasi sent me and we are good. We have no objection to number 7. Per exhibit 7.
Thank you. Then in that case, Madam Hearing Examiner, I will upload it and then if you want to see it before you determine that to accept it into the
Yes.
record. Okay, I will upload
yes,
it. And
please.
I will upload it and I will also send it to everybody via email.
Very well. Then I believe there were 3 NEE exhibits. That were offered and objected to. And Hearing Examiner Schaefer and I said we were going to take a look at. And I am ready to rule on those 3. Exhibit 5, NEE Exhibit 5. finding it in the Dropbox. NEE Exhibit 5 was an article or comment entitled "The Ill-Fated Petra Nova CCS Project. NRG Energy Throws in the Towel." After reviewing this exhibit, the basis for offering the exhibit and the objection to the exhibit, I am going to deny admittance of this exhibit. I don't believe there's been an adequate foundation. I think there's a question of relevance, and not having the purported authors of it available to question them. So 5's denied. Number 9. We'll go to number 9 is joint applicants for supplemental response of April 10, 2025 to New Energy Economy's first set. And this interrogatory was with regard to a BCP applicant. I had allowed Ms. Nanasi to have a brief question about this person as in limited scope as part of transaction cost. This interrogatory goes further to ask more information with regard to the consultant's work, and I believe that potentially the context of any relevance of going further than this was somebody who's involved in the transaction cost, and has the potential to, in the implication of influence is not proven, calls into question for me its relevance, and I believe that potentially it has more of a prejudicial effect than any type of probative value it might have. Exhibit 9 is denied. Wrong button. Hold on, let me pull the exhibits up again. Okay, and then with regard to NEE Exhibit 8. NEE Exhibit 8 is joint applicant's third supplemental response of February 12th to New Energy Economy's first set of interrogatories and production of documents. Consists of interrogatory 1-28 regarding Petronova and Mr. Baudier's employment with Petronova. 1-29, which also is with regard to Petronova. And does that still include, Ms. Nanasi, 1-34 regarding mergers?
Um, it does include that.
And if I'm understanding, Mr. Alvidrez, you are objecting to all of NEE Exhibit 8, or are you just objecting to parts, particularly E and F of 1-34?
Your Honor, Will Dubois fielding this one this morning.
Okay,
Give me one moment, catching up. I believe that is to the entire interrogatory.
okay. So the objection was to the entire interrogatory.
Yes, Your Honor.
Okay. After reviewing the assertions made by NEE, and considering both the support for admitting NEE 8 and the objection to NEE 8, I believe that in reviewing the transcript and Mr. Baudier's answers, that and especially regarding the year that he spent with this particular project, I believe that NEE 1-28 is relevant, and therefore I think 1-28 should be admitted for the same reasons, since 1-29 does relate to or 1-29 does relate again to Petronova, and he answered a question on the record before before the objection could be ruled on. I'm going to find that 1-29 is also relevant. Now, with regard to 1-34, one 34 is regarding prior mergers to which BCP was a party. A, list and provide references for and all claims and commitments that BCP made about benefits.
I'm sorry, Judge, can you repeat that list, Ann?
Yes, sir, I can. List, comma, and provide references for, comma, all claims and commitments that BCP made about benefits.
Thank you.
Thank you, sir. I think that's clearly relevant. B, What reason did BCP provide to support each benefit? Again, I think BCP's prior acquisition legal claim uh, is relevant. C, for each claim, which individuals were responsible for producing the results? I'm not sure that's real clear to me about which results they're talking about. So I don't know. D, for each claim, what were the results? So I guess considering results of whether the merger was successful or not, in that context, C and D, I think, are also relevant. Then we get into E and F. E, what amount of money did BCP donate to each and every Louisiana commissioner and why? And F, provide all internal BCP communications about the reasons for making donations to Louisiana commissioners in advance of the BCP takeover of the utility. After considering the support for offering this information, as well as the objection, I don't believe an adequate foundation has been laid as to the appropriate relevance claim to the current proceeding. And I believe that the inference of that could be drawn from this without having an appropriate legal claim could result in a prejudicial impact that is outweighed by any probative value that might result from it. Therefore, I find that an adequate foundation was not laid, and that the appropriate requirement for relevance in this case, along with the potential prejudice, causes me to find that interrogatory part E and F of 1-34 should be denied. I do find, however, that A, B, C, and D are relevant and potentially to the commission's consideration. The commission can consider this other merger activity to the extent it feels that it should, and give it any weight it deems appropriate. Therefore, A, B, C, and D of 1-34 are admitted. So with that, Mr. Nasi, what I would like you to do is I would like you to resubmit NEE Exhibit 9 without sections E and F. And then just for compliance review, I'll take a look at that. But I am going to admit 9, except
Eight.
8, sorry, gonna admit 8, the parts of 8 that I just said I would admit. So if you would do that when you can, I'd appreciate it.
Madam Hearing Examiner,
Yes, ma'am.
as you can see, the BCP did not answer A, B, C, or D. So I'll just remove knee interrogatory 1-34 from the entire exhibit, and I will upload a new one that will just have 128 and 129 in it. And
Very well.
I did upload New Energy Economy Exhibit 7. I also sent it to all the parties, and it is New Energy Economy 7, which is the joint applicant's response to NEE's first set of interrogatories with supplements to 1-10, 1-38, 1-42, and 1-45.
Okay, that's the one I need to look at.
Yes.
Okay. Thank you. Anything further?
No, thank you.
Thank you. Okay, I think that leaves my list of weekend homework from the parties. And I believe then we can go ahead with the presentation of our next witness. I believe I see you moving, Mr. Haverly. Do you have the next witness?
I do, Madam Hearing Examiner. So if it
Go ahead, sir.
pleases the hearing examiners, the joint applicants call Lisa Quilici to testify.
Good morning, Ms. Kalichi. Welcome.
Good morning, thank you.
Mr. Lee, would you swear the witness, please?
Ms. Quilici, will you please raise your right hand? Do you solemnly swear the testimony you're about to give, no matter not pending, should be the truth, the whole truth, nothing but the truth?
I do.
Thank you, ma'am.
Go ahead, Mr. Haverly.
Thank you, Madam Hearing Examiner. Ms. Quilici, would you please state your name for the record?
My name is Lisa Quilici.
Ms. Quilici, who are you employed by and what is your position?
I am employed by Concentric Energy Advisors. I am a senior vice president with the firm.
Ms. Quilici, you have in front of you what has been marked as joint applicant exhibit number 16. Do you see that exhibit?
I do.
Do you recognize it?
I do.
What is it?
It is my revised application, direct testimony, and a single exhibit attached to it.
And was this testimony and exhibit prepared by you or at your direction?
It was.
Do you have any changes to what has been marked as joint applicants exhibit 16?
I do not.
If I asked you the same questions today, would you provide the same answers as contained in joint applicant exhibit number 16?
I would.
Would those answers be true and accurate to the best of your belief and understanding?
Yes.
Madam Hearing Examiner, I move to introduce joint applicant exhibit number 16.
Any objection to what's been identified as joint applicant exhibit 16? Ms. Quilici's direct testimony as affirmed by her here today. Hearing no objection, joint applicant exhibit 16 is admitted.
Ms. Quilici, you also have in front of you what has been marked as joint applicant exhibit number 17. Do you recognize this document?
I do.
What is it?
It is my revised application rebuttal testimony.
Was exhibit number 17 prepared by you at your direction?
Yes,
Do you have any changes or corrections to joint applicant exhibit number 17?
I do not.
If I asked you the same questions as contained in joint applicant exhibit number 17, would you provide me the same answers today?
Yes, I would.
And those answers would be true and correct to the best of your knowledge and belief?
Yes.
Madam Hearing Examiner, I respectfully move for the admission of joint applicant exhibit number 17.
Any objection as to what's been identified as joint applicant exhibit 17, Ms. Quilici's rebuttal testimony as affirmed by her here today? Hearing no objection, exhibit 17 from joint applicants is admitted.
With that, Madam Hearing Examiner, I will tender the witness for cross-examination by the parties and for further examination by the hearing examiners. Thank you.
Thank you, Mr. Haverly. I believe I don't believe in an area had any questions. Ms. Manassi moved her time. WRA didn't have any questions. Aha. CCAE reserved 30 minutes for Ms. Quilici. Ms.
Yes,
Lynch or
thank you, Madam.
Mr. DeSalen?
Thank you, Madam Hearing Examiner. We did reserve 30 minutes, but we have no questions for this witness at this time. Thank you.
Thank you. Mr. Freeman, you reserved 15 minutes for Ms. Quilici?
Yes, Madam Hearing Examiner, we did, but FEA also doesn't have any questions at this time for this witness.
Thank you. That brings us to staff, who reserved 20 minutes for Ms. Quilici.
Yes, thank you, Madam Hearing Examiner. Like the other parties, we reserve some time and we don't feel we need to use it at this point. So staff will be waiving that 20 minutes.
Very well. Hearing Examiner Schaefer?
Yes, good morning. Thank you, Hearing Examiner Hurst. Ms. Quilici, thank you so much for being with us today. I have a few questions for you. Can you firstly describe to us how you became acquainted with this transaction?
Of course. Good morning. I was retained, I believe, through counsel for this transaction. I became aware of it generally when it was announced, and then more specifically upon retention.
Are you being retained in your individual capacity or through Concentric Advisors?
I have been retained through Concentric Energy Advisors.
Have you provided testimony for any entity related to joint applicants in the past?
Thinking for a moment. And I do not believe that I have. No, I was trying to think even more broadly. Have I worked directly with either of these counterparties on a transaction? And I don't believe that I have.
And what was the request of the joint applicants with respect to engaging you in this transaction?
I was engaged to address issues pertaining to the acquisition premium and goodwill in the transaction, I was also asked to review the transaction process, the competitive process that led to the transaction. And then upon filing of testimony by interveners, I was asked to respond briefly to some of the concerns that were raised by WRA and CCAE or CACE. I apologize if I got the acronym incorrect.
No worries. How many hours have you worked on this transaction?
I am honestly not certain, but I would put it in the area of 100 hours or so. Best guess.
You produce any other reports or analysis other than the direct testimony and rebuttal testimony that has been entered into evidence?
I also prepared testimony prior to the refiling of the application, which I believe was just a piece of rebuttal testimony. And I have responded to, I believe, one interrogatory.
And you're appearing here as an expert witness, is that correct?
That is.
Ms. Kalicha, I'd like to draw your attention to your revised direct testimony. It's Exhibit 16.
Yes, I have that.
And there's a question I'd like to ask you related to the question I suppose you asked yourself on page 7 at line 4. And it reads, is this the transaction akin to the sale of a regulated asset? Is that the question you posed in your revised direct testimony?
It is.
And can you tell us why you posed that question?
Sure. I anticipated that this would be a question of interest to parties intervening in the application for the transaction. It is a question that is typically asked when considering the acquisition premium.
What the distinction or what can you describe the distinction you were trying to describe in that question with the answer?
Of course. The transaction at hand is the sale of the entire business, the entire utility, which is a collection of physical and intangible assets. Whereas the sale of an individual asset is, as the titling suggests, the sale of a single asset. In this circumstance, the sale of an individual asset, that typically happens when the asset is no longer necessary for the provision of utility service. So the asset is sold, it's removed from service, it's removed from rate base, and the proceeds from that sale flow back through rates to customers. That is not the circumstance that we're faced with here. Here, all of the assets of NMGC, physical and intangible, are being sold or proposed to be sold. Those assets, physical assets, will remain in rate base. They will continue to provide utility service to customers.
Are you aware if this transaction is yielding a profit or a loss for Emera?
I can't answer the question specifically. What I can say is I'm aware that there is an acquisition premium. I'm aware that there was an impairment taken from the acquisition premium paid in the prior transaction. I believe that question with regard to profits or losses or is better directed to another witness, Ms. Hutt, probably.
You have extensive experience with mergers and acquisitions of utilities nationwide for several decades. Is that correct?
It is.
What is the frequency or commonality of utilities being sold for a loss?
I think that it's unusual, but again, as it pertains to transaction to transaction, if a given utility is transacted more than once in a reasonable time frame, I would have to actually evaluate that more specifically to answer with full information.
What, in your experience, could it mean if a utility is being sold at a loss?
I'm sorry, could you ask that again? I missed the beginning.
Sure. What are some of the reasons you've seen in your experience professionally that gives rise to a utility being sold for a loss?
Thank you. So utilities are sold for lots of reasons, and typically it's driven by the seller determining that that utility is something that they would rather deploy elsewhere, that they feel that they need to focus on other elements of their business. That's a pretty common reason for a company to enter into a transaction. And making that strategic decision would then influence the utilities or the companies, excuse me, evaluation of moving forward with the transaction, whether it was at a gain or a loss.
To draw your attention to a subsequent question that you posed yourself on page 8, and specifically at line 4, if you could tell me if I'm asking your question correctly, you write, do you have examples of utility investor risks? Is that correct?
It is.
And why did you pose that question?
For a similar reason to why I posed the question with regard to the sale of individual assets. I, based on experience in other transactions, assumed that parties would be interested in understanding whether investors in a utility had meaningful risk, and if so, what those risks might be.
You describe those risks. Maybe elaborate a little bit on your answer here.
Sure, I'd be happy to. So the risks that I talked about here were sort of general categories, and there are a number of categories of risks, right, that investors face. Here I talked about the potential risk of bankruptcy, which is a more remote risk, but it is a real risk nonetheless. I provided an example with regard to PG&E. There are other examples as well. There are regulatory disallowances, returns that are earned that are less than authorized. There are risks that happen in the marketplace every day when an individual shareholder that holds stock in a publicly traded corporation sells that stock at a gain or a loss. They take the risk of gain or loss on that individual investment. It really is just a normal part of business as an investor.
Kind of insolvency risk do you see? What kind of insolvency risk upstream do you see for the target companies here? New Mexico Gas Company, New Mexico Gas Intermediate, and TECO.
You're asking me to hypothesize on future risks that could occur?
I'll ask the question maybe a bit more piecemeal. Are you aware of the intended corporate and capital structure of the proposed transaction?
I have not looked at that, no, sir.
Okay, so you're not aware of the funding of Saturn Utilities Holdco and the manner in which that funding will be used to acquire the target companies. Is that correct?
That is correct. That's not something that I've evaluated.
Okay. The evaluation that you provided with respect to the bids and decision to proceed with BCP applicants, can you describe the conclusion of your review of that bid process?
Sure. Let me back up and describe a little bit about what I looked at and what I did, because I think that might be helpful in terms of context. So I have worked on an enormous number of transactions, both on the buy side and the sell side. So I've actually run transaction processes before. And in that capacity, I was asked to take a look at what was done to evaluate whether this comported with industry standards or didn't, and if it didn't, how it didn't. So I undertook a review of documentation, things that were provided throughout the process. I interviewed Ms. Hutt as having been more directly involved in the process, and then I stepped back and evaluated using my experience to determine my thoughts on the process. Based on all of that, I concluded that the transaction was fairly standard. Competitive solicitations of this nature have a very distinct pattern, and this followed that pattern pretty closely. You retain, excuse me, not retire, retain a qualified financial advisor. They did that with JP Morgan, a very qualified advisor, in my experience. The advisor establishes a process in consultation with the prospective seller and provides a series of information. The steps that were taken were pretty standard. Reach out to a large universe of potential parties, see who's has potential interests, enter into non-disclosure agreements with folks that have interests so that you can then start providing the materials upon which they can conduct their due diligence. Those fireside chats, the information memorandum, all of that kind of stuff is very common in these transactions. And then going through there's multiple rounds of bidding, indicative bids, inviting parties to provide final bids, and then entering into negotiations is a very standard approach to a competitive solicitation. I hope that answers your question. If it doesn't, I'll keep going with
No, thank you, Ms. Koichi. That's very, very helpful and informative. So you don't have any deliverables or scope of work regarding the proposed capital structure or corporate structure of the proposed transaction?
No, sir, I do not.
It's limited mostly to the fairness and openness of the bid process and the sophistication of the bid process, and also testimony regarding the acquisition premium. Is that correct?
That is correct.
Madam Hearing Examiner, I have no further questions. Thank you. Thank you, Ms. Koichi.
Thank you, sir.
Thanks.
Thank you, Hearing Examiner Schaefer. I've just got a few questions for you. Guess I'm going to start out with Ms. Koichi. Welcome. Have you testified here in New Mexico before?
I have once before.
And did you get your pots over there and behind you, near the window, when you were here?
I did not. I got them years ago on another lovely trip to New Mexico.
Very well. In consideration of risk, are you considering that you have any risk hanging your horseshoe upside down back behind you?
My daughter made that adorned horseshoe, so it can go upside down, sideways, and I will be fine.
Are you familiar with some people who always hang it so your luck stays up?
I am. I live on a small property that has horses, so I'm familiar with a lot of the idiosyncrasies.
Of equine behavior. Very well. Obviously you have vast experience, and have indicated your 35 years of experience working in your consulting capacity with electric and natural gas industries. Do you also provide services for non-regulated industry?
My firm does, but I personally tend to work with utilities most of the time. I can't recall a non-regulated entity that I have provided advice for in recent years.
And in your work with regard to utilities, are they always regulated utilities?
Yes, some have interesting regulatory dynamics. Like I've done some work for the TVA, which is a regulated entity, but not like NMGC is.
Okay. And with that work, how many approximately merger and acquisition cases do you think you've analyzed or testified in?
So I believe I've testified in 5 merger and acquisition cases. I have analyzed dozens of merger and acquisition cases, and actually I misspoke a little bit. I have worked in the context of evaluating potential buyers of assets, non-regulated entities. On occasion, I will work with an investment fund or a private equity investor who is looking at the potential acquisition. I was focused more on things that are public when I made my response to your initial question about who I've represented.
So then when you provided testimony in these mergers and acquisition cases, have you always testified for the applicant or the
Generally,
acquiring? Let me further specify the acquiring entity.
and I will say generally, yes. The one exception that I can think of is I testified in the GPE Westar merger, and I believe I was jointly retained by both the buyer and the seller in that instance, where I was actually truly representing both in every way.
And you say you have done analysis for private equity companies regarding potential purchase of utilities,
Yes,
but not BCP.
correct.
Do you believe that there's any difference or actually, is there any difference in your analysis of these dozens of merger and acquisition cases where it's private equity that's attempting to acquire the public utility?
Are you asking, is there any difference in how I would evaluate that kind of thing?
Yes.
In general, no. The due diligence is very consistent regardless of the buyer. And I will say each transaction is different. So in each transaction, you need to look very carefully at the individual circumstances. So the categories of inquiry are generally the same, right? I mean, there's a whole level of operational quality of infrastructure and all of that sits into one bucket. There's a whole financial bucket in terms of the financial capabilities on both sides of the transaction, the obligations on both sides of the transaction, whether the transaction would create different financial profile if it were to close. There is a whole fit, for lack of a better word, evaluation of whether the management companies, the management teams, excuse me, from both sides of the transaction can work well together through the pursuit of regulatory approvals and through the closing. There is a strategic fit component of how the acquired company would then fit in with the buyer. So there's lots of categories that are very consistent regardless of who the buyer and or the seller are. And then they take on their own unique nuances as you move through looking at the potential transaction. I will say that as it pertains to a potential private equity acquirer, workforce commitments in terms of the local workforce are important considerations, but they are regardless of who the acquirer is.
I just wondered if you had potentially any difficulty in trying to educate certain non-utility acquirers of the duties and obligations that may be different from their corporate structure to the duties and obligations that a public utility has?
That's an excellent question. And I will say, in my personal experience, advising non-utility acquirers who are interested in acquiring utility companies, they typically spend a lot of time, a disproportionate amount of time, understanding what the regulatory framework is to be sure that they are fully comfortable and that they've reflected that framework in their financial modeling. There's a very important intersection of understanding and building that into your view holistically of the potential acquisition. So I wouldn't say that I've had difficulty educating folks in that regard. These are sophisticated people who are willing to put up a substantial amount of funds in order to have the opportunity to bring that utility into their holdings. And typically the folks that I've worked with, if they are not fully accepting and embracing of what that means, they don't move forward and go any further than the initial inquiry.
And I think, yeah, I think difficulty was not the word I wanted. But I think based on your testimony, for some of them, there's perhaps you have to spend some time educating them on the differences, right?
Yeah, for first time buyers, for first time folks who are looking at a utility investment for the first time, yeah, certainly there's generally speaking a little more time spent in the understanding portion of it. For folks who have done this before, there is still time. And I will frankly say, even for utility acquirers of utilities, there is always time spent on understanding the regulatory framework that exists in the jurisdiction that is at hand, right? That happens irrespective of who it is. But for a first-time acquirer, there's a little more time spent for sure.
Is it not just about understanding the differences and the processes, but for example, in this particular transaction where there's a lot of different layers of intermediate companies and investment and management, is there also potentially the impediment of going from a private equity structure to for example, the structure in this case, of being a publicly traded company and control? Do you think, well, go ahead and answer that.
So I'm going to preface it by saying these are not things I really considered for this specific transaction, scope of my retention. If you would like me to offer sort of a general view based on my experience, unless someone knocks me over the head and tells me not to, I'm happy to do that.
Sure, go ahead.
So, I mean, surely there are differences, right, to go from a private equity to a publicly traded endeavor, right? I think that was the question. Was that the question? Let me ask before I.
Well, yeah, I mean, I guess basically to hone in on what I'm trying to understand is a private equity company has, with its structure, has more control over over its fate and its course than a public utility does, doesn't it?
Typically speaking, yes, depending on where their investments are, they have investment parameters and guidelines and things of that nature, which dictate certain things. But as pertaining to comparing a regulated utility subject to your jurisdiction, this commission's jurisdiction, it's a different, generally speaking, a different framework.
And in your experience, have some of the non-public potential acquiring companies had an issue with having less or different control?
Yes, certainly I have worked with folks who have taken a look at utility investments and decided against them for a variety of reasons, right? And it isn't always just control. Usually, not usually, when an entity looks at a utility, they understand going into that look that there are lots of rules and regulations and requirements and limitations on returns and all of that that go into this investment. Folks who continue to take steps forward are folks who embrace that. No one goes into this thinking that they're going to change the fundamental structure that exists. In my experience, I've never seen that. And in fact, there are often regulatory commitments that are made to make that point crystal clear. I'm not intimately familiar with the regulatory commitments made here, other than those pertaining to the acquisition premium. But as my testimony discusses in a couple of different places, it is very clear that NMGC is subject to the regulation of this commission, that it will continue to be subject to the regulation of this commission, and that is something that the prospective buyer has embraced.
And with regard to your rebuttal testimony, especially in response to Dr. Blank, the staff witness's testimony, about the acquisition premium and goodwill, you're disagreeing with his recommendation regarding the acquisition adjustment, aren't you?
I am.
Are you aware of any jurisdiction or any case that you have previously worked on that has followed his recommendation?
I am not, no. I believe I responded to an interrogatory that asked for information pertaining to my comments in my rebuttal testimony about regulatory precedent and not having seen this before. And in assembling that list, there were more, I believe, going by memory, more than 140 cases, proceedings that have occurred in the last 10 or 15 years that I'm aware of, that I have over the course of my career, that I've reviewed the orders and applications, and in some cases testimony, in some cases directly participated. And in none of those cases has the acquisition premium been used to determine an amount of customer benefits. Dr. Blank's, there are positions similar to Dr. Blank's that have been taken directly in other proceedings, a little bit different. In some cases, folks have recommended an allocation of the acquisition premium to customers. Dr. Blank did not do that. He recommended the establishment of a regulatory liability in the amount equal to the acquisition premium, or another amount, which he specified in his testimony. premises are similar, and in no to the other proceedings where similar positions have been put forth. And as I said, in none that I'm aware of has the acquisition premium been used as a foundational element in the determination of customer benefits. Customer benefits and public interest determinations are made, generally speaking, on their own. And the existence of an acquisition premium, which is not unusual at all, is its own separate component that has no impact on customers.
When you started reviewing this and you saw the impairment, did that surprise you?
I wouldn't say that it surprised me. I mean, I'm not an accountant. I know that impairment tests happen annually. I have seen impairments. I worked on a transaction a year or two ago where there had been an impairment prior to the transaction happening. I can't recall other examples, but didn't really surprise me. These things happen. And frankly, it's one of the reasons why the commitments with regard to no flowing of any acquisition premiums through rates are so important for customers.
Very well, Ms. Alici. That's all the questions I had for you.
Hearing Examiner Hurst, I
Thank
have
you.
just one or two follow-up questions.
Yes, Hearing Examiner Schaefer, please go ahead.
Thank you. Thank you. Thanks again, Ms. Calici. Very much appreciate your time. This is to follow up on some of the questions from Hearing Examiner Hurst with respect to your rebuttal testimony, and I'm looking specifically at page 2 and lines 15 through 17. Page 2, lines 15 through 17. And you state there, if I'm correct, this position, that is Dr. Blank's position, this position is both outside the norms of utility regulation in North America and in conflict with economic and financial principles that underlie these regulatory norms. Did I describe that correctly?
Yes, sir, you did.
I'm wondering, in your experience, what is in your view, the motivation for such a proposal if it is so iconoclastic and has no bearing on the norms of utility regulation in North America?
So I hate to opine on Dr. Blank's motivations. I will say in other proceedings where I've seen, taking it as a whole in both this proceeding and other proceedings, it appears that parties sometimes look at the acquisition premium and go down a path of saying, well, customers should have more. Investors are making money if they are, which I think is a question in this particular case, but that seems to be what motivates folks as a way to establish some measure of customer benefit that has a dollar amount attached to it. But I'm not entirely certain what motivated Dr. Blank.
Is this proposal by Dr. Blank consistent with any kind of regulatory school of thought or regulatory accounting or regulation theories that you're aware of?
No, sir, not that I'm aware of. I believe earlier you asked me a question as it pertains to the sale of an individual utility asset. And I think that is one thing that comes up as a justification. But it does, as I say in my testimony, and I stand strongly on this statement, it really is not at all consistent with the underlying premises of regulatory rate making or of the economic and financial principles upon which these transactions sit.
In your experience, have you seen such proposals increase in frequency in over time?
I have not. There are lots of transactions where these proposals are not made. I can think of at least one transaction where the public advocate actually said that goodwill has no value at all. There are half a dozen or so transactions that come to mind where this type of proposal has been put forth but not accepted. And when I say this type of proposal, I want to be really clear. It's not Dr. Blank's proposal exactly. It's that the acquisition premium in some way should have some bearing on customer benefits is the proposal I refer to.
Well, thank you again, Ms. Kalichi. That is the extent of my questions following on Madam Hearing Examiner's Hurst question. So thanks again for being with us today. I appreciate it.
Thank you.
Thank you, Hearing Examiner Schaefer. Mr. Haverly, any redirect for your witness?
No, Madam Hearing Examiner, I have no questions based on the examination by the hearing examiners.
Very well. Anyone have any cross, I guess? Anyone have any questions for Ms. Kalichi based on Hearing Examiner Schaefer and my questions? Hearing none. Thank you very much.
Oh,
Ms. Nanasi?
if I could, I did raise my hand, but it wasn't registered. Could I ask Ms. Kalichi a couple of questions?
Sure.
Madam
Thank you.
Hearing Examiner, this is Brian Haverly. May I be recognized for a moment?
Yes.
Any waive their cross on this witness, Madam Hearing Examiner? I think it's highly unusual for somebody to be granted more or less a recross after waiving the witness and giving up their right to cross in general. So I would object.
Okay. I have a my procedure is to let the parties ask questions based on the questions that I or the commission asks. I think that's only fair. So even though Ms. Nanasi had otherwise allocated her time, I'm going to afford her a few questions based on Hearing Examiner Schaefer and my questions.
Yes, ma'am.
So your objection is overruled. Go ahead, Ms. Nanasi.
Thank you. Good morning, Ms. Kalichi. There was only one actual offer, and that was by BCP to Amera. Is that correct?
Yes.
And you did testify in the Avangrid Iberdrola P&M merger case. Is that right?
It is.
And how much are you being paid in this case? Or have you been paid, or do you expect to be paid, I should say?
I honestly do not know how much my firm has been paid to this point. I'm not being paid directly. My consulting firm is, my employer is. I'm happy to provide that information separately, but I don't know the answer off the top of my head.
How much per hour is concentric charging either the joint applicants or BCP for your testimony?
My hourly rate is somewhere on the order of $750 or $780 an hour, something in that range.
Nothing further. Thank you.
Thank you, Ms. Nanasi. Any further questions? Not hearing anything. Again, Ms. Kalichi, thank you so much for your appearance here today, and you're excused.
Thank you.
Very well. I think probably Mr. Lee, should we take our break now?
Yes, ma'am.
Okay, we're going to take a 10-minute recess and we'll come back with our final joint applicant witness. It's 10:25. We'll come back at 10:35. Make sure you recognize that the YouTube is still on. Thank you.
Okay.
How are we doing, Mr. Lee?
Good, Judge. I'm ready when you are.
We got 1 minute. All right, Mr. Lee, if you're ready.
Yes, Judge.
Thank you, sir. We are back from our morning recess. And Mr. Hatherley, or do you have the next witness?
This is Will Dubois. I do, Your Honor.
Very well, Mr. Dubois. Good morning, Miss Kelly.
Good morning, Madam Hearing Examiner.
The BCP applicants call Acquisitiion Kelly.
Very well. Mr. Lee, would you please swear the witness?
Mr. Kelly, would you please write, thank you. You solemnly swear the testimony you're about to give to matter and opinion should be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, ma'am.
Thank you, sir. Go ahead, Mr. Dubois.
Ms. Kelly, could you please state your full name for the record?
Sudeen, a middle initial G, Kelly.
And you have what has been marked as joint applicants exhibit number 18, titled Revised Application Direct Testimony and Exhibit of Sudeen Kelly, dated July 3, 2025, consisting of 33 pages and 1 exhibit.
I have that, yes.
And were exhibit 18, including its exhibit, prepared by you or under your direct supervision?
Yes, it was.
And to the best of your knowledge and belief, is that a true and correct copy of that document?
Yes, it is.
If you were asked those questions again here today, would your answers be the same?
Yes, they would.
And do you have any additions, corrections, or deletions to
No,
exhibit
I
18?
don't. No, I don't.
Do you also have in front of you what has been marked as joint applicants exhibit number 19, titled Revised Application Rebuttal Testimony and Exhibit of Sudeen Kelly, dated October 10th, 2025, consisting of 36 pages and 1 exhibit?
Yes, I do.
And were exhibit 19 and its exhibit prepared by you or under your direct supervision?
Yes, it was.
And to the best of your knowledge and belief, is that a true and correct copy of that document?
Yes, it is.
If you were asked those questions again here today, would your answers be the same?
Yes, they would.
And do you have any additions, corrections, or deletions to exhibit 19?
No, I don't.
With that, Your Honor, move exhibits number 18 and 19.
Very well, Mr. Dubois. Any objection to what's been identified as joint exhibit number 18, the revised application direct testimony of Ms. Kelly as affirmed by her here today? Hearing no objection, joint exhibit 18 is admitted. Any objection to what has been identified as joint exhibit 19, revised application rebuttal testimony of Ms. Kelly as affirmed by her here today? Hearing no objection to joint exhibit 19, it is admitted. Mr. Dubois?
And with that, Ms. Kelly is available for examination, Your Honor. Thank you.
Thank you, sir. According to my list, in an area, I believe reallocated its time as did NEE. WRA had no questions. I believe CCAE allocated 5 minutes to cross-examination for Miss Kelly. Mr. DeSalen or Ms. Lynch?
Yes, hearing examiner, I have a few questions.
Go ahead, Ms. Lynch.
Okay, nice to meet you, Ms. Kelly. My name's Kara Lynch. I'm an attorney for the Coalition for Clean Affordable Energy. Could you please, thank you. Could you please turn to page 23, lines 5 through 9 of your rebuttal testimony?
Yes.
I'm getting feedback from somebody that has something in the background. Go ahead.
I have that in front of me now, Ms. Lynch.
Thank you. I apologize for any feedback. I do share an office space. There, on page 23, lines 5 through 9, you state in response to examination of WRA's witness or analysis of the witness testimony, quote, I believe this argument is fundamentally flawed because it overlooks the fact that the BCP applicants also can recoup their investment by preserving or increasing the overall long-term value of New Mexico gas as a going concern so that they are able to earn a comparable or larger acquisition premium if and when they sell their interest in New Mexico Gas Company to a new owner. Is that correct?
Yes, that is what it says.
Okay. And here, the cost of the acquisition premium is the investment that gets recouped, correct?
No, that's not my understanding of the term acquisition premium.
What do you mean then by a comparable or larger acquisition premium?
A comparable or larger acquisition premium in regulatory utility accounting has to do with the value of the intangibles that the intangible assets of the company.
And here you state those can be comparable or larger, correct?
Upon the sale of the company, let's say BCP applicants is permitted to buy the company, then upon its sale to another owner in the future, then it could sell the company for a larger or the same acquisition premium or value of the intangible assets.
Okay. Thank you, hearing examiner and Ms. Kelly. Those are my questions.
Very well, Ms. Lynch. Mr. Freeman, I believe that FEA had reserved 15 minutes for cross-examination of Ms. Kelly. Go ahead, sir.
Madam Hearing Examiner, we did, but at this time, FEA has no questions for Ms. Kelly.
Very well. Then we move over to staff. Mr. Friedman or Ms. Lang, staff reserved 90 minutes
Yes,
of
ma'am.
questions or time. Go ahead.
Thank you, ma'am. Katie Lang on behalf of staff. Good. Is it good afternoon? Oh, no. Good afternoon. Are you in Albuquerque?
I'm in Albuquerque, yes.
Okay, well then, good morning.
Thank you.
It's been a multi-regional hearing, and I just wanted to say the correct salutation. Let's see. Could you go to, please, I'm going to refer you to what has been marked as Joint Applicants Exhibit 19, which is your revised application rebuttal testimony.
Yes.
If you could please go to page 24.
Yes, I have that in front of me.
I have a few questions regarding some your testimony on page 24 and part of 25, but For the sake of completion, would you mind reading into the record, please? Starting on the question, which is on line 1 of page 24, till page 25, the middle of line 5, where it ends not by its customers, if you could.
Sure. The question is, do you agree with staff witness blank's recommendation that, quote, an amount equal to the goodwill paid to the sellers at closing of this transaction should be booked as a regulatory liability to customers, end quote? And the answer, no. Dr. Blank recommends that, quote, an amount equal to the goodwill paid to the sellers at closing of this transaction should be booked as a regulatory liability to customers, end quote. With use of this regulatory liability account to, quote, be decided by the commission at a later date, end quote. Although Dr. Blank claims he is not recommending sharing of the acquisition premium, that would in fact be the practical effect of his proposal. Indeed, Dr. Blank himself acknowledges that, one, his proposal amounts to a recommendation that the value of the goodwill reflected in the acquisition premium, quote, should be transferred to customers as part of this transaction. And two, the purchase price may, quote, need to be renegotiated for the buyer and seller to share in that amount to customers. As I explained in detail in my direct testimony, I do not believe the public interest would be served by requiring NMGC to record the acquisition premium as a regulatory liability or otherwise share the acquisition premium with customers. Based on my experience, I believe this recommendation is inconsistent with fundamental principles of public utility regulation and well-considered precedent. In particular, I am concerned that adopting Dr. Blank's recommendation would create confusion about who ultimately bears the risks, that is, bears the financial responsibility for a public utility's success or failure. For privately owned public utilities like NMGC, those risks properly must be borne by the public utility's owners, not by its customers.
Thank you. I appreciate you reading the all of that into the record.
Will do, Your Honor. Yeah, one quick clarification for the record.
Mr. Dubois?
I would just like to note, we did not read in, nor do I think we need to, but did not read in that there are footnotes in that passage, and would just note that the answer does continue after that.
Very well. Go ahead, Ms. Lang. You have a question?
Yes, ma'am. Ms. Kelly, you have extensive experience in the public utilities regulation arena, correct?
Correct.
Could you share with us, please, what your understanding of the term liability is?
Liabilities are generally indebtedness. A regulatory liability is typically an account that reflects money that customers have paid the utility for future expenses when those future expenses come to be less than what was paid in. And so a regulatory liability typically is the repayment of funds to customers who paid them in early.
Could you also tell us, please, what your understanding of the term equity is?
Equity? Equity, when a utility needs capital, if it is an investor-owned utility, it raises capital from two sources: a debt, which I think everyone knows what debt is. It's an obligation to pay the lender back. And equity. And equity is money that is invested by investors. They could be shareholders if it's publicly owned, or private investors into the, say, the infrastructure fund. And that is that portion of the utilities capital is called equity. There is not an obligation on the part of the utility to pay those investors back either a dividend or the value of their investment, although there is an expectation on the part of the investors that they will make money on their investment.
Thank you. You are no doubt familiar with for a chart of accounts or uniform system of accounts, correct?
I'm sorry, I lost part of your question. Did you say, am I familiar with the uniform system of accounts?
For FERC, yes, that was a question.
Yes, I am familiar with it.
So you are no doubt aware that regulatory liabilities are booked in FERC account number 254.
No, I'm not aware of the account number.
Okay. Are you also, well, I have to ask you now. Are you aware that dividends declared from retained earnings are booked in FERC account number 438?
No, I'm not.
I would like for you to please go to page 30 of your rebuttal. And I have a question that's really focused on your statements on page 31, but and I apologize, it's kind of long, but if you could read it into the record, please, starting at page 30, line 10, that is the question, till the end of your answer, which is on page 32, line 4, if you could.
Sure. The question is, staff witness Zadalis recommends that joint applicants should provide funding for a severe weather fund in lieu of their proposed economic development and charitable contribution commitments. Do you believe it was reasonable for joint applicants to maintain their customer rate credits, economic development, and charitable contribution commitments rather than voluntarily adopting this proposal? And the answer, yes. Mr. Zadalis proposes that the joint applicants should contribute $12.5 million of initial funding for a severe weather fund that would, quote, serve as an offsetting relief fund to protect New Mexico NMGC customers from primarily extreme weather-induced natural gas specifically swing gas price surges, end quote. Mr. Zadalis notes that the joint applicants committed to provide $10 million for economic development and $2.5 million in charitable contributions in connection with this transaction, and argues that, quote, the public interest is better served if the monies committed by the joint applicants for economic development and charitable activities are redirected, end quote, to the severe weather fund. In my experience, commitments to provide specific monetary contributions to fund economic development and charitable initiatives are widely recognized as a method of providing public benefits in connection with proposed mergers or acquisitions involving public utilities. And then I have a citation to several cases that support that point. By contrast, Mr. Zadalis does not reference any decisions of this commission, recognizing that a fund or mechanism similar to the proposed severe weather fund necessarily provides public benefits. In light of this record, it is reasonable for the joint applicants to believe there is some uncertainty about whether the commission would view the proposed severe weather fund as providing public interest benefits comparable to or greater than the originally proposed economic development and charitable contribution commitments. Accordingly, based on my experience, I believe it was reasonable for the joint applicants to maintain their commitments to customer rate credits, economic development, and charitable contributions rather than shifting course and adopting Mr. Zadalis's proposal voluntarily.
Thank you. I appreciate that. Ms. Kelly, you are no doubt familiar with the six-factor test, correct?
Yes.
In your opinion, do the economic development and charitable initiatives provide any direct benefit to ratepayers of NMGC?
Some go to the ratepayers and others, as I understand the commitments, are commitments to developments in the same community where ratepayers are. Oftentimes a ratepayer is a head of household, and so other persons in that household who are not the ratepayer, but nevertheless live in the household, would be persons that would benefit from those contributions.
Is that your understanding of a direct benefit?
Pardon me?
Direct benefit. Is that your, what you just
Yes, I think I don't understand your question.
Let me rephrase, I apologize. Your testimony just now describing the benefits of the economic development and charitable initiatives. At the end of it, my question was, is that your understanding of what constitutes a direct benefit to ratepayers?
I think that they do, as proposed, constitute a direct benefit to ratepayers.
In your preparation for your testimonies, both direct and rebuttal, did you review New Mexico PRC case 3056?
Can you tell me what that case is about?
It is about it is the case where the staff had recommended and the recommended decision recommended, and it was the commission adopted the creation of a hedging fund.
I don't recall it. It may be that I reviewed it, but I don't recall it.
Thank you.
Whose testimony was that in?
That was in Mr. Ryan Shaw.
Okay, I thought you said staff.
Oh.
You said it's the case where staff had recommended.
In that case.
Okay, and the commission adopted creation of a hedging fund?
Correct. But that 3056 is cited by Mr. Shell in his rebuttal.
Okay. Thank you. Go ahead.
And that is all I have, actually. Thank you very much.
Thank you.
Very well. I believe I that hearing examiner Schaefer. Sir, you have some questions for Miss Kelly?
Yes, thank you, hearing examiner Hurst.
Thank you.
Mr. Harris, you've raised your hand.
Yes, thank you, Hearing Examiner Schaefer and Madam Hearing Examiner. I know that at the beginning of this hearing, I waived my cross-examination. I'd like to seek a partial withdrawal of that and ask City and Kelly some questions based on her statements concerning the severe weather fund.
This. Where are you, Mr. Harris?
I'm in my office.
Okay, I don't see you. It's just the reason I ask.
Oh, maybe if I turn on the video.
There you go.
Yes.
Mr. Dubois?
Your Honor, obviously this is unusual and no time has been reserved. I suppose I would not object up front and would simply leave it without comment to Your Honor and Hearing Examiner Schaefer's judgment, with reserving that depending on whether you allow it and how long it goes, I may ask for revisit.
Very well. You're correct, Mr. Dubois and Mr. Harris, that the Department of Justice did basically indicate they were waiving cross of all witnesses. They withdrew their witnesses' testimony and indicated that they would participate, if at all, by briefing. However, now there's been a request from NMDOJ to ask Ms. Kelly some questions. It is unusual. Can't say I've had it happen before. But I think in the interest of the public interest, I'm going to allow it. And depending on the length, Mr. Harris, go ahead and ask your question, sir.
Thank you, Madam Hearing Examiner, and I will be brief. Ms. Kelly, Brian Harris, I'm with the Department of Justice, obviously. I wanted to, if I could characterize your testimony concerning the Severe Weather Fund, you do not agree with it, is that correct?
I would say that the point that I was making was the criticism of New Mexico Gas Company for not voluntarily agreeing to transfer the offered benefits from the offer that was made to the Severe Weather Fund.
Was part of your reasoning also that it's a departure from normal practice?
One of the reasons that having the Severe Weather Fund be funded now is that it hasn't been fully vetted by the commission yet. I believe that there's a better forum for discussing the pros and cons of this proposal. It involves potentially very complex policy questions about the risks and adverse financial impacts associated with severe weather impacts and who should pay and who should pay what and whether it should be mandatory or voluntary. It's an interesting proposal, and it may be that it is a proposal that the commission ultimately would like to adopt. But as far as the procedural posture is, I think the question you asked, is I believe that it would be better vetted and understood in a different kind of proceeding, perhaps a rulemaking where many of or all of the stakeholders who would stand to benefit from such a fund could have input.
Thank you. As a very general proposition, do you think it's reasonable to change past practice in light of new conditions?
The commission is always able and has the authority to change past policy based on new circumstances.
And as a general matter, you wouldn't disagree with the need to do that. Your main complaint is that this is the improper procedural vehicle. Am I correct in asserting that?
Well, that's one of my concerns, yes.
What is your other concern?
My other concern is the point that I just made in answer to Ms. Lang's question.
Okay.
In my rebuttal testimony.
Now, if there was a severe weather fund created, would it earn interest?
I don't know what the proposal is.
I have no further questions, Your Honor. Thank you for indulging me.
Thank you, Mr. Harris. Hearing Examiner Schaefer, I believe you had some questions, sir, for
Yes, thank you.
Ms. Kelly.
Thank you, Hearing Examiner Hurst. Good morning, Ms. Kelly. Thank you again for being with us. My first question is if you could describe how you came to be involved in this transaction.
I came to be involved in this transaction through counsel for a gas company of New Mexico that told me that there was an application pending and direct testimony had been filed and that several issues had been raised and that they thought that I might make a good witness if I agreed with their position on those issues.
Are you appearing today as a member of your law firm or on an individual basis?
I am appearing today through my law firm.
Who ask you if you are familiar with the capital and corporate structure of this transaction.
I am generally familiar with it, yes.
I would like to ask you a question regarding your question that you posed yourself on page 7 of your revised application.
And that is my direct testimony, Mr. Hearn?
Your revised direct testimony. Yes, that's correct. Thank you.
Yes, I have it in front of me.
And with respect to the question on lines 1 and 2, why did you pose that question to yourself?
The question, if I am understanding you correctly, is what are your key conclusions regarding private equity ownership of public utilities?
That's correct.
Right. I posed that question because that was an issue that was raised previously before the direct testimony on private equity ownership of public utilities. And I was asked to address it.
And in your testimony, you make distinctions about different kinds of private equity transactions. Is that correct?
I think that more precisely, I make distinctions about different investment strategies and portfolios of private equity companies.
And can you describe how the strategy of this private equity transaction differs from the other strategies that you referred to in your testimony?
This private equity investor is interested in utility infrastructure, and it attracts the fund attracts investors like the Canadian Pension Fund that are interested in long-term stable investments so that they can invest in those kind of investments because they have long-term financial obligations like to the pensioners. And so this private equity fund is interested in the kinds of investments that are investments in public utilities.
Can you describe the relationship between long-term vis-a-vis pension funds and long-term vis-a-vis the commitment, the time commitment to hold New Mexico Gas Company as intended by the joint applicants?
Well, pension funds are interested in investing in stable investments that are stable over the long term, as well as in order to fund their long-term obligations. So they tend to eschew the volatility of stocks and other investments that might be very might have a very high return, but might have a very low return for a stable investment that is going to last or to be stable over the life of the investment.
In your experience and knowledge, does long-term, that term long-term, have a technical meaning vis-a-vis pension funds or institutional investors?
I don't know that it has a technical meaning.
And in this case, the proposed investment of BCP applicants in New Mexico Gas Company is characterized as long-term as well. Is that correct?
Yes.
And what is that time frame?
My understanding is that the commitment has been a minimum of 10 years.
And would 10 years also constitute a long-term investment vis-a-vis pension funds?
Yes.
That would be considered long-term investment. I wanted to ask you also about further down in response to this question, specifically lines 12 through 17. And I don't think we need to belabor our time by rereading it out loud, but I'd like to ask you about the different points you make here in this sentence. And the first is that you say ownership by this type of private equity fund can provide benefits for public utilities and their ratepayers. Can you describe those benefits to the ratepayers and then contrast that with other ownership structures or capital structures, maybe even with respect to the current ownership structure?
Certainly. The first one that I identified was insulation from certain short-term financial pressures and interests in the long-term financial health of the utility.
Okay, let's start there. Yeah. Mm-hmm.
Thank you. What I was referring to was public equity, which is equity that is traded on the stock market publicly. Public equity has quarterly reports and quarterly reportings and quarterly earnings calls. And those companies face quarterly pressures to meet the expectations of their shareholders. And they also face pressures to show a stable, sustainable, if not ever increasing return for the shareholders. A private equity does not have that pressure. And the private investors are looking to see their investment be managed for the long term. for the 10 years or longer, so that it is so that the company is kept financially healthy, so that at the end of the investment, it returns the investment, preferably with a profit.
In your response just now, you stated that those companies face this is publicly traded companies or companies that rely on public credit markets and debt markets. Those expectations, sorry, it's moving as I read it to you, the transcript. Those companies face quarterly pressures to meet the expectations of their shareholders, and they also face pressures to show a stable, sustainable, if not ever increasing return for the shareholders. Is that true with utilities? Are they facing ever increasing return from shareholders?
I believe that they face those pressures, yes. And that's, of course, why we have regulation.
Are utilities guaranteed an ever increasing rate of return as opposed to another type of private company that's able to increase their rate of return?
No, they're not. But what we're talking about here are expectations of shareholders. And public equity competes with various companies for investors, and investors in utilities could be investors in Google or Meta, and may, depending on those investors, may pressure or extend expectations that the company will make those kinds of returns.
So why would any company choose to rely on public markets and otherwise be subject to quarterly reporting?
That's been historically, that was the basis of equity in the United States, was public equity. Private equity is an evolution, if you will, of capital formation that has occurred over the last 40 years. And it is, of course, still evolving, but as there is more and more experience of investors with private equity, we're seeing investor capital expand into the private equity market.
Are you saying that companies that are publicly traded and are required to report earnings and other financial information are riskier than private equity funds because they don't have to report?
No, I'm not saying that.
So is there any risk to a company that doesn't report as a publicly traded company would report?
The risks to private companies, to companies whose equity is privately funded, the risks of the business are the same. The issue that I was talking about was the expectations of the investors.
And the expectations of the investors, if I understood you correctly, could create a risk. Is that what you were saying? The short-term financial pressures, is that indicative of a risk?
It's not a risk, it's a pressure. It's a short-term financial pressure.
And that would be a risk to ratepayers.
The risk of the short-term financial pressure is the risk placed on a company, or the pressure placed on a company to make short-term decisions that will please the shareholders, potentially at the expense of a better longer-term decision.
And that longer term decision in the current proposed capital and corporate structure would be immune from any kind of financial reporting that could cause short-term financial pressure. Is that what you're saying?
No, I'm not saying that. I'm saying that they're not required to meet quarterly earnings calls.
Quarterly earnings calls would create a risk to ratepayers.
Not a risk to ratepayers. It is a pressure on the company to meet quarterly expectations, as opposed to when it might want to, in a perfect world, it might want to either take a loss in that quarter in order to take a gain in a year, as opposed to feeling pressure to always have to meet the same return or more each quarter.
And generally, in your experience and professional sophistication, why do publicly traded companies have to report to the SEC or to shareholders? What's the purpose of that reporting?
It is a SEC regulation of all, and the SEC regulates all publicly owned companies.
And why does the SEC require reporting?
To ensure that the multitude of public shareholders are informed.
Is that the sole reason?
I don't know. I'm not a securities expert, but I think that's the primary reason.
Okay. Now, going further in this sentence, in this response on page, I believe that's 7, one of the other benefits that you identify is reliable access to capital for prudent investors or for prudent investments. So can you describe why this provides a preferable or greater and even reliable access to capital for prudent investments?
Sure. I would like to clarify, though, that I'm not saying it's better. I'm saying that it is different. I'm saying that it's reliable access to capital for prudent investments. And what I am contrasting it with is when you have public equity and you have stock and it's publicly traded, then the stock prices change all the time. And there is often a volatility in that price. And events within the utility can send that price suddenly up or down. If that price goes down, that means that the shareholders are leaving. The equity is coming out of the company. The price is going down. The amount of equity in the company decreases. And if the utility needs money, needs more equity at that time to fund an investment, it's hard to get. I think I could take Pacific Gas and Electric as an example. When they were subject to bankruptcy, and then first liability for, in California, there's strict liability for to electric utilities for wildfires and liability for wildfire damage. That risk and the fact that that risk was visited upon PG&E sent its stock price down. PG&E has wanted to invest and expand its transmission network. it does not have access to the capital that it needs because its stock price is depressed. And it is instead looking to other equity providers to partner with. So that's what I'm referring to. When you have an investment fund, the investors in that fund commit to an infusion of equity. They make their investment, and that equity in that fund can't be pulled out.
Thank you. So just some clarifying questions. The equity contributed to the fund is different than the equity possessed by the utility, correct?
Yes, the equity that is in the fund is separate from. And then the equity that's in the fund is invested in the utility.
In this transaction?
Yes.
So what funds is BCP Infrastructure Fund 2 GPLP investing equity into Saturn Holdco, Saturn Utilities Holdco?
I'm not sure if, yes, I believe so, but yes.
Is
No,
BCP
maybe not into Saturn. Sorry, I don't understand exactly who's investing what. Saturn Utility Holdco is investing, and my understanding is that BC Infrastructure Funds is also investing.
I'd like to go back just to your response to my previous question. And if I'm not mistaken, you were describing that publicly traded companies' ability to acquire equity depends on their stock price. Is that correct?
Yes. It
You were
depends on
saying,
a variety of things, but yes, that's one of the things.
and is it possible that the value of New Mexico Gas Company could also fluctuate regardless of whether its shares are traded publicly or not?
Internally, the value will change, yes.
So is the benefit for reliable access to capital for prudent investments a function of publicly traded shares or a function of the value of the underlying utility?
Well, I think it's a little more complicated than that. What I was talking about here is the fact that with a private equity infrastructure fund, investors put their money in that fund for a long period of time. So the money is there, you can count on it. With a publicly traded company, the investors, first of all, there are usually many times of investors. There are small investors like you and me who buy shares in companies. And we do not have a commitment to keep our money in that company. And we may pull it out.
And is there any benefit to having that kind of flexibility from a management perspective? That is to say, let me rephrase the question. If I'm managing New Mexico Gas Company, is there any benefit to having my shares publicly traded?
Sure.
What are they?
Well, that wasn't what I testified to, but I'd be happy to try and answer the question. What as a company, what you're looking for is equity. You're looking for capital. And you can get your capital by structuring your company as a publicly traded company, meaning you can get your capital through investors in your shares, in your stock. Alternatively, you can structure your company so that your equity comes from private equity. And that is the money in an infrastructure fund. Both of those are forms of capital that are available to companies. And they make that decision, and usually it doesn't change unless and until the company is sold.
Further on in your testimony on page 7, you state that one of the other benefits for ratepayers is more direct accountability for utility management. Is that correct?
Yes.
And more direct than what?
But more direct, because there are a smaller number of investors in a private equity fund, then they are more directly usually more directly overseeing that investment in that company, as opposed to you or me as a shareholder. And if we bought shares of Gas Company of New Mexico, we are in all likelihood not holding Gas Company of New Mexico directly accountable. We may look at our stock price and our dividend record, but we are not as directly, Gas Company of New Mexico isn't as directly accountable as a matter of practice.
And would accountability also be characterized as short-term pressures from the market?
In the case of a private equity fund, no, because by definition, it's a long-term investment.
Thank you. I have a couple more questions. Are you aware of the proposed capital structure of Saturn Utilities Holdco?
No.
Do you know the amount of the loan that Saturn Utilities Holdco is proposing in this transaction?
No, I don't.
What risks upstream does Saturn Utilities Holdco bear by, let me rephrase the question. Mr. Baudier, in his testimony, and just for the record, I'll state it here, not that you have to turn to it, Ms. Kelly, but this is on page 33 of Mr. Baudier's testimony. I'm just saying this for the record and for the parties. And it's at the top of the page on 33. How will Saturn Holdco, Saturn Utilities Holdco, fund the purchase of the equity interests of TECO Energy? And Mr. Baudier here goes on to describe both the equity and the debt in the capital structure. And in describing the debt, he says $250 million of private debt. In your experience, what does that mean? What does it mean, private debt?
I don't think I know what he was referring to there. I would be walking out on a limb if I tried to answer the question. I'm sorry.
In your expertise and experience, what do you know about private debt markets versus public debt markets?
It's not my area of expertise.
He also goes on to say that this debt that Saturn Utilities Holdco will be non-recourse to New Mexico Gas Company. How can the loan or the debt held by the upstream Holdco be non-recourse to the downstream utility?
Well, my understanding just from a common understanding of non-recourse loans means that the lender gives Saturn X amount of money. Saturn contributes that to gas company. And the lender, should Saturn default on their loan payment to the lender cannot, it has no recourse to gas company of New Mexico for that default.
Generally speaking, abstractly speaking, not specifically with respect to the terms and conditions of this transaction, is that non-recourse function within the loan agreement, or is it due to the capital and ownership formation between New Mexico Gas Company, Gas Intermediate TECO, and the upstream holdco?
I don't know the answer.
Okay, so I guess maybe let me rephrase the question. Is non-recourse lending, in your experience, between companies, a question of contractual terms or a question of the corporate structures that underlie the companies hierarchically?
I'm afraid that your questions are beyond my area of expertise.
Okay. I guess my final question is that, does this current transaction, proposed transaction, the corporate and capital structure, do you see any risks here vis-a-vis the prior or the current ownership structure?
My understanding is that with the ring fencing that has been committed to, that there should not be any concern about risk from or to or with upstream owners.
So, regardless of the regulatory commitments or the proposals from joint applicants, based on your review of this proposed corporate and capital structure, what areas do present a risk for the utility as the utility or for ratepayers?
I do not believe that the ownership structure presents a risk. The utilities has obviously business risks, but not the ownership risk.
So would you recommend that all utilities be owned by such an ownership structure?
No.
Hearing examiner Schaefer, I think that you cut out, even though your mouth was moving.
Sorry, I said why not?
I'm not testifying that private equity or public equity, that one or the other is better. I'm testifying that private equity is a known form of capital, of equity, and that it is an acceptable form of equity for utilities.
That's all my, go ahead.
For utilities.
For utilities. Ms. Kelly, thank you. Don't let the seriousness of my demeanor suggest anything other than gratitude for your time here with us. And I have no further questions, Ms. Hurst.
Thank you, Mr.
Thank you. Thank you, hearing examiner Schaefer. Ms. Kelly, I've just got a few questions for you. Are you a New Mexico Gas Company ratepayer?
Not now.
In your direct testimony, when you're summarizing your qualifications and education, you indicate that when you were a FERC commissioner, the decisions that you made included proposed mergers and acquisitions. That's correct?
That's correct.
Do you recall having any acquisition cases similar to this that were that involved private equity?
I don't specifically recall one as a commissioner, but I've represented the Morongo Band of Mission Indians that formed a transmission company and along with private equity. And we submitted a request for approval of that to the commission in, I believe it was 2015, 2016, after I had left the commission.
Okay, and you're specifically referring to the commission as FERC.
Yes,
correct?
I'm sorry, that's right.
And you also, again, in page 3 of your direct, are referring to your qualification and expertise. And you reference your 4 years as a commissioner here in New Mexico to one of the predecessor commissions of the NMPRC, the New Mexico Public Service Commission, correct?
Yes.
And during your tenure at the PUC, do you recall making any decisions in a merger or acquisition case with regard to a private equity acquisition?
No, I don't. I recall that I was one of the commissioners in the acquisition by Public Service Company of New Mexico Gas Company, but obviously that was a publicly traded company.
And also during your experience and expertise, have you participated either as an attorney or consultant or witness in the acquisition cases that have been referenced here, that being the prior gas company acquisition cases, or the El Paso Electric acquisition case, or the attempted P&M acquisition case?
I did not appear in any of those, no.
Have you appeared in any acquisition cases as a witness, consultant, or an attorney in any other acquisition cases before this commission that I didn't reference?
I do not believe so, no.
And I'm going to go to the same page that hearing examiner Schaefer was looking at, your page 7, which the question was posed at line 1. What are your key conclusions regarding private equity ownership of public utilities? And just to follow up on one of his questions, you used PG&E as an example of risk and what can happen to a publicly traded company that affects their stock price, right?
Yes.
In addition to the strict liability for the wildfire Weren't they also impacted by their gas explosion that killed people, including a California Public Utilities Commission employee?
I suspect they were, yes.
So to go back here to item 7, at the bottom of the page, beginning the sentence at line 19, while I do not agree with the assertions that there are inherent risks to private equity ownership that are additional to publicly traded ownership, I also emphasize that the commission has at its disposal the regulatory authority needed to address concerns about private equity ownership of New Mexico Gas Company. That's your testimony.
Yes.
Can you elaborate on what specific authority or on page 8, again, regarding key conclusions on the acquisition adjustment, you say at line 4, the commission has and will continue to have authority to enforce this commitment. So if you can just elaborate on the authority and what tools you believe the commission has to enforce the commitments made by joint applicants,
Sure.
not gas company, but the acquiring joint applicants.
Sure. The commitments that have been made can become enforceable if and when the commission in its order makes those commitments and a condition of approval, and then would have ongoing enforcement authority to ensure that those commitments were kept. And the commission also has, of course, great authority over rates and services and adequate provision of service and just and reasonable rates, and has authority over issuance of securities, and has authority to demand books, records, and accounts. That are all tools that the commission has available to it to ensure that the company operates in a just and reasonable way.
Well, I know continuing on in your testimony, you specifically refer to Rule 550. And your belief that the commitments that have been made that regarding the joint applicants comply with that, correct?
Is that the class 2 transaction rule? Yes.
Yes, ma'am, it's the GDP rule. And you also refer to commission authority trying to find the site. You cited the definition of affiliate. So aside from the statutory and rule requirements, and I guess trying to put them into context, your conclusion is that the rules and the statutory authority that the commission has are sufficient to have the same or similar regulatory authority over private equity that they would have over a public over a publicly owned utility, correct?
Yes.
Do you believe that the practicality, having been a commissioner, both at the state level and at the federal level, with the press of business and or employee uh, uh, availability, uh, uh, budgeting concerns with regard to employees, etc. Do you believe that potentially that might be a limiting occurrence uh, over the jurisdiction uh, of this particular private equity company if the transaction is approved?
Madam Hearing Examiner, could I ask you to restate that question? I lost you there. Sorry.
Okay. Basically, I'm just wondering whether or not, based on your knowledge and experience as a state and federal commissioner, you know what it is to be part of the authority that runs the agency and what limitations are placed on that agency with regard to how much work you have, what your budget is, how many employees you have, what's the level of knowledge of the employees, correct?
I think that what you're saying is that the Public Regulation Commission, like every regulatory commission, has a budget it has to stay within. It has a certain number of employees, and I think what you're asking me is the commission to able to provide appropriate regulatory oversight of private equity, of a private equity owned utility versus a public equity owned utility. I think
Yes,
that's what
ma'am.
you're asking. Yes. I don't see any difference in the oversight that is needed for a private equity owned utility versus a public equity owned utility.
Okay. So you don't think it necessarily, even though it's a newer type of regulation than that the commission has encountered, you don't necessarily think that places any burden on the commission staff to investigate or review a private equity owned utility as opposed to something that's more familiar to the staff, a publicly owned utility.
No, and I guess I would clarify that it's not new regulation. It's the same regulation. It's a new form of capital, but the regulation is the same. That capital is capital and equity is equity. And so the regulation of a private equity funded versus public equity funded utility is the same. It's still oversight of just and reasonable rates, insurance of adequate service, making sure that the securities issued are appropriate, following any class 1 or class 2 transactions. And that in this instance, in addition, the commission has the tool of the commitments. So I don't see that the regulation of it isn't any different than if it maintained its public equity owned status.
Okay, thank you. And again, I just want to get to this. What if have you looked at the commitments?
Yes.
So do you think it's fair to say that some of the commitments, for example, are general in nature and not necessarily tied to a specific rule or regulation of the commission?
Well, my recollection and subject to check is that many of them are very specific, like no rate changes, no recovery, no seeking recovery of any increase in goodwill and rates, a commitment to a 5-year investment plan, a commitment to a $22.4 million rate credit, no rate case before September 30th, no selling of the interest of BC applicants for at least 10 years. So an agreement to the jurisdiction of the PRC for purposes of providing books and records of each owner in the structure. So I think many of them are very specific.
Okay. And I guess again, just trying to think ahead a little bit when considering the commitments, well, some of them may be very, or all of them the commission may consider to be very beneficial. I'm just trying to visualize how the commission would enforce the commitments if they weren't tied to some kind of, number one, are there going to be enough, how would the commission find out if gas company wasn't giving preference to New Mexico suppliers in supply of their food chain, supply chain goods and services, or I'm sure somebody probably would complain, but I don't know that for a fact, right?
That's exactly what I was going to say, because somebody will complain.
Exactly. And then the question becomes, with the press of business, how long does it take to, or does staff have the resources to do that, or the commission, or something like number 27, if required by the commission, gas company would have an allocation study, which would not be charged to ratepayers. Well, performed by a consulting firm and at the direction, choosing of the commission and at the direction. I don't know how some of these have teeth in them. But
Well, I think for that one, what they're saying is that if the commission asks us to do an allocation study, we're not going to object, and we're not going to charge the ratepayers.
or like 53, gas company will not incur, guarantee, or pledge assets for any new incremental debt related to the consummation of the transaction. How would you suggest that the commission would find out about any pledged or assets for debt?
Well, probably through the commission's securities issuance authority.
And I don't know what it was at the time you were here, but are you aware that those financing cases are on a 30-day timeline?
Whoa.
And that basically from the automatic assignment to the notice to the testimony and then back to either be heard or the issuance of a recommended decision is already quite challenging. And I mean, do you think the commission could actually have the resources to potentially identify in that kind of short security proceeding have a meaningful opportunity to discover any irregularities?
Well, I would hope they would, and I assume that that's the legislation, that's the legislature that put that burden on the commission, and hopefully the legislature gave you sufficient budget increase to meet your burden.
We always try.
Yeah.
Okay. Anything else on the commission's jurisdiction or their enforcement opportunities for any of the assertions that have been made by the joint applicants?
I think I've listed them all.
Okay, very well. Thank you, Ms. Kelly. That's all the questions that I have for you. Mr. Dubois, any redirect for Ms. Kelly?
No, thank you, Your Honor.
Very well. We'll go back. Mr. Gould, I saw your hand raised first. Did you have any questions based on the cross or the hearing examiner's questions?
Madam Hearing Examiner, based upon your questions and Hearing Examiner Schaefer's questions, I have 2 or 3 questions, please.
Go ahead, sir.
Hi,
Ms.
Mr. Gould. It's good to see you again.
I was going to say, it's hard for me not to say Professor Kelly.
It's hard for me not to say Peter.
Okay, we know each other from law school where she was in charge of my grades at the administrative law classes, but
And I recall that you were a straight A student, so.
Well, I've forgotten everything I learned in law school and had to relearn it. Anyway, you had mentioned in your colloquy with Commissioner Schaefer, I mean, not Commissioner Schaefer, I've just promoted him, with Hearing Examiner Schaefer, the risks associated with the pressures of being a public utility company with the short-term nature of its investors. Do you recall that back and forth?
I do.
Are you aware of any of those pressures in the last 10 years, if you know, where gas company has been owned by a publicly held company, where it has been underfunded because of that?
I do not know. I didn't follow the stock history of gas company.
Okay. And my other question, and you and Hearing Examiner Hurst talked about the disasters that that happened with PG&E. Do you recall that?
Yes, I do.
And hopefully never happens in New Mexico, but if something of that size and importance happened in New Mexico, wouldn't it be better for gas company to be owned by a public utility company has a capitalization of 30 billion versus a series of funds that are only capitalized to the extent of 2 billion?
I would think that the liability for a wildfire would be, first of all, litigated. In California, they determined that it's strict liability. In New Mexico, I do not believe that is the law. So I don't believe they have to have an infinitely deep pocket. And I think that their capitalization is sufficient, or well, as you know, it wasn't even sufficient in PG&E. They went into bankruptcy. So.
Right. Well, thank you for that answer, and nice seeing you again. Thank you.
Thank you, Mr. Gould. Ms. Nanasi, I believe you also had your hand up.
Thank you, Madam Hearing Examiner. Good afternoon now. Ms. Kelly, my name is Mariel Nanasi. I have a couple of questions for you. Is it your understanding that private equity was behind 70% of the large US bankruptcies in the first quarter of 2025 with over $1 billion in liabilities?
No, I'm not aware of that.
What effect would it have on New Mexico Gas Company if BCP went bankrupt?
My understanding is nothing, no effect.
Has New Mexico Gas Company ever had a problem accessing capital?
I do not know.
Do you know that in 2024 that private equity-backed company bankruptcies had reached a record high?
No.
Nothing further. Thank you.
Thank you, Ms. Nanasi. Any other questions for Ms. Kelly? Hearing none, Ms. Kelly, thank you so much for your time. You're excused.
Kelly.
Thank you.
I believe, Mr. Dubois, does that conclude the joint applicant's presentation of its witnesses in this case?
That does, Your Honor. Thank you.
Very well. I have we've got 12:07. Why don't we break for lunch? And we'll break for an hour. We'll come back. I believe, Ms. Nanasi, you have your witness ready to go, and we will begin with him. Just remember the YouTube is on. We are recessed for 1 hour. Thank you.
So till 1:07?
Yes.
Okay. Mr. Lee?
Yes, ma'am.
Can you?
We off the record?
Yes.
Yes, sir.
Okay, go
Mr.
ahead.
Lee, remember you have asked Mr. Sandberg in the past, and if you could ask him to affirm and not swear, would you be willing to do that for him again?
Yes, ma'am.
Thank you so much.
You bet.
See you. Sydney, you know that you're on video.
I'm ready when the time comes, Judge.
All right, Mr. Lee. All right, sir. Let's go back on the record. We are returning from our luncheon recess. And over the luncheon recess, I had indicated I would review NEE Exhibit 7 that I believe has been agreed to with the changes and NEE Exhibit 7, which is entitled Joint Applicant's Response to New Energy Economy's First Set of Interrogatory and Requests for Production of Documents.
If I may, Your Honor, with supplements 110, 138, 142, 145 updated.
Very well. And this is 17, 18, 19, 10, 32, 33, 35, 37, 38, 42, 45, 51, 56, I think that's it. I believe that representation was that upon review, there's no objection. Now that I've reviewed it, NEE Exhibit 7 is admitted. And you were going to redo NEE Exhibit 8. and resubmit. And that's joint applicant's third supplemental response of February 12th to New Energy Economy's first set of interrogatories and requests for production. 1-28. One dash 29, and that's it. With my ruling and the edits on the exhibit, NEE Exhibit 8 is admitted.
Thank you, Your Honor.
Thank you. Ms. Nanasi, I believe that you have a witness for us today.
I do. I will just say that Mr. DeSalen's hand is up, and I don't know if you want to take him or not.
Okay. Let me look. I was looking at the Dropbox. Mr. DeSalen.
Thank you, Madam Hearing Examiner. Just quickly, I want to let you know that at 2:30, I have a pre-hearing conference in another matter, and so I will be dropping off, but Miss Lynch will be here covering CCAE. That's all.
Okay, thank you, sir. Okay. Also, I guess before we call Mr. Sandberg, just want to alert people that if there are witnesses potentially that might be able to appear this afternoon, um, uh, other than the two that we already have, cross-examination seems to be dropping like flies today. And I want to the extent we can, fill up our time. I know after Mr. Sandberg, we have staff witnesses, Zigich and Tupler said they'd be available. And so that if there's any other witnesses, if we need you, be thinking about that parties. And I guess this might also be an appropriate time. And this is not a this is not a criticism, so please don't take it that way. This is a request. I know sometimes it's really difficult to project how much time you might have for cross-examination for a witness, just as it's difficult to predict how many days we might have to have for a hearing. So I know these things are difficult. I know some people are newer at this than other people. And then I know sometimes things that happen during the course of the hearing can also change cross-examination projections. But to the extent we can, we want to try to be as accurate as we can, just to help out the scheduling of the witnesses and the days for hearing. So with that, Ms. Nanasi, you have a witness.
Yes, I do. Thank you, Your Honor. Mr. Lee, could you ask for Mr. Sandberg's affirmation, please?
Well, we need to call him first.
I call to the Zoom stand, Christopher K. Sandberg.
Thank you. Mr. Lee, would you please get the witness well, I don't know, we call it sworn in, but yeah.
Mr. Sandberg, would you please raise your right hand? Do you solemnly affirm the testimony you're about to give, no matter not pending, shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Ms. Nanasi.
Mr. Sandberg, could you please state your name and spell it for the court reporter?
Christopher Sandberg, CHRISTOPHER, SANDBERG. And I can't tell from my end of my volume, okay?
Yes, sir.
Yes.
Okay, thank you.
Did you prepare direct testimony and exhibits of Christopher Sandberg in response to the revised application on behalf of New Energy Economy on September 26th, 2025?
I did.
Has New Energy Economy designated that as Exhibit 1? New Energy Economy Exhibit 1.
Yes, ma'am.
Is it true and correct to the best of your knowledge?
Yes, ma'am.
If I were to ask you the same questions today, would you give the same answers?
I would.
Your Honor, on behalf of New Energy Economy, I move admission of New Energy Economy Exhibit Number 1, the testimony of Christopher Sandberg in response to the revised application.
Mr. Sandberg, do you have any additions, corrections, or deletions to that testimony?
I do not believe so, no.
And you have approximately 22 attachments to your testimony. Is that correct?
I can scroll down and double check. That sounds right. Let me, it's a long PDF. Yes, ma'am.
And did you prepare those exhibits? Or were they prepared under your direction and control?
Yes, ma'am.
And if you answered that question, is there any objection to what has been identified as NEE Exhibit 1, the direct testimony of Mr. Sandberg as affirmed by him here today?
Including the exhibits, Madam Hearing Examiner?
Well, those are attached to his testimony, yes.
Madam Hearing Examiner, I would object to several of the exhibits attached to Mr. Sandberg's
Okay,
testimony.
tell me what you're objecting to, Mr. Domi.
I would start, frankly, Madam Hearing Examiner, with exhibits numbers with CKS number 7.
Okay, and your objection?
My objection is that that's an article that is prepared by a party who is not a witness in this case. And the extent to which Mr. Sandberg is relying upon that is not clear from his testimony.
So it's a foundation, it
would be a foundation exhibit, Madam Hearing Examiner.
or it's a foundation
Objection.
objection.
Hearing Examiner, yes, it is an exhibit. It's a foundation objection to that exhibit.
Okay, what else?
The same holds true, Madam Hearing Examiner, for number 8, number 9, number 10. I would also object to number 11, number 12, number 13, number 14, on grounds of both foundation and relevance. They talk about hospitals and private equity, healthcare and private equity, healthcare system and private equity, and U.S. electric companies and private equity. none of which are an issue in this case. I would object to number 15, the Elite case, as not both foundation and relevance. The comments of the Attorney General in the Elite case are just that, comments of a party to a case. There has been a recommendation by a hearing examiner in that case, and there will be a final order in that case that are more final than the Attorney General's comments. And then just to round this out, I would object to 16, 17, 18, and 19 as all relating to the El Paso case and specifics in the El Paso Electric case, which admittedly is a private equity case, but which has no relevance to the issues in this case or the conduct of the parties in this case.
So relevance on that 1, 2, 3, 4. Okay. Any others?
No, no objections to 1, 2, 3, 4, 5, 6, or 21, which deals with natural gas, and 22, which is a repeat, frankly, of exhibit number 4, but also deals with this case.
Okay, what about 20?
Oh, 20 is fine. That's interrogatory response of Mr. Shell. That is applicable both foundationally and relevance wise.
Okay. Ms. Nanasi?
Thank you. First of all, I believe that Mr. Domi's objection are too late. This was supposed to be the result of a motion in limine, I believe, and I think it violates your procedural order. This testimony has been in the record since September 26th. There's been lots of time for the joint applicants to have made such an objection. I think it's absolutely fair in the law in this state and at the PRC that experts are allowed to rely on documents of their choosing. Of course, they can be cross-examined on those documents. But Mr. Sandberg has been accepted as an expert in at least a handful of cases at this point. And he has relied on these documents to form his opinion. And that's, that these are essentially research documents that he used to draw his conclusions and his opinions. So I think that they should be accepted.
Okay. Do you want to put in a position on each of the objected to
I mean,
exhibits, or do you just want hearing examiner Schaefer and I to broadly construe your comments to all of them?
Well, I think that of all the ones that he objected to, the basis was the same, was foundation and relevance. So I think that they're obviously relevant to Mr. Sandberg's opinion because he used them to make his opinion in part in this case. The other thing is that the El Paso Electric is commission precedent here. So I think all of those are absolutely relevant. And so, yeah, I would ask you to deny Mr. Dome's objection in total for its tardiness as well.
What about what about the exhibit 3, which is an excerpt from a deposition? Why is that an appropriate
Well, first of all, Mr. Domi didn't object to exhibit 3, but second of all, it goes to one of our theories in this case that the only or the primary concern of BCP of America, excuse me, with BCP was the price it was going to pay to acquire an MGC. And that is an excerpt from Mr. Baudier's deposition, and it goes to the impeachment of both Amera and BCP, frankly. And that's what Mr. Sandberg's testimony is about, that there was no public interest determination by Amera when it chose BCP, for instance, that it was just based on price.
okay, I'm going to take this matter under advisement and till I've had an opportunity to confer with hearing examiner Schaefer. However, subject to ruling definitively on exhibits, CKS exhibits 3, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, and 21. Those are being taken under advisement. I do not believe there was any specific objection to the testimony. And subject to my ruling, we can go ahead unless there's an objection and continue with the cross-examination of Mr. Sandberg.
If I can, Madam Hearing Examiner, I don't believe that Mr. Dome objected to 20, 21, or 22, and I will just say that 20 is an interrogatory in this case. 21 is a statement by a party opponent. This is a BCP article that was written by BCP, and Mr. Sandberg there was lots of testimony about the quote blueprint that BCP has for acquiring natural gas assets. So I think that is for no one objected to it, and also it's been asked and talked and cross-examined about. So those 20, 21, and 22 have not been objected to. I think it's only
Okay.
7 through 19.
Madam Hearing Examiner.
Mr. Dome.
Yes, Ms. Nanasi is correct. I didn't object to 20, 21, and 22. I did mention that 22 is duplicative of 4. And as for 3, I did not object to that one, Madam Hearing Examiner, because the quote that is in that is in the testimony, and it's in the testimony. On
Whose
page 12.
testimony?
Mr. Sandberg's testimony on page 12, line 14. The phrase in the deposition for which the deposition excerpt is being attached, as I can tell from the testimony.
And I realize you didn't object to it, but I have an issue with it.
Yes, ma'am.
Okay, and I want to discuss that issue with hearing examiner Schaefer. Not necessarily used to having depositions used other than for impeachment purposes. And not you, I'm not familiar with having a part of a deposition being offered when there was an opportunity to examine the witness on the statement. Ms. Nanasi, did you ask Mr. Baudier about the statement in the deposition?
Not explicitly about that, but I believe that some of the exhibits that you've already admitted, including Ms. Hutt's testimony, that was the number. I mean, we will brief this, that price was a number one issue in the transaction. Also, there was lots of questions to Mr. Baudier and Ms. Hutt about the omission of the public interest, and though in the lead up in the decision making process of the transaction. And
so the answer was not specifically.
I did not ask him, did he say that in his deposition, but the topic was a topic of cross-examination by not only me, but others to Mr. Baudier and Ms. Hutt.
And are you claiming that he denied the substance of the quote in the deposition?
No, I'm not saying that he denied it. I think it speaks volumes, though, and it's an important fact of this case.
Okay, 21 is a BCP publication that you're not objecting to. Is that correct, Mr. Domick?
That is correct, ma'am. I'm not objecting to it.
Okay. All right, well, I see it. And I suppose if you're acknowledging it comes from BCP and it's true and correct, then I'll mark that off. Okay, no. Okay. The introduction of NEE Exhibit 1 is taken under advisement. Go ahead, Ms. Nanasi.
Mr. Sandberg is available for examination.
Very well, thank you so much.
Madam Hearing Examiner,
And
Mr. Gould has his hand up.
Yes, Madam Hearing Examiner, I may be out of order and you will tell me that if I am, but I just found some of your statements with respect to Ms. Nanasi's exhibit or the testimony of Mr. Sandberg troubling. The rules of civil procedure and the commission's rules allow depositions as a normal form of discovery. And we have used, and perhaps you can hash that out when we get to Mr. Walters. So that's how we've used it as well. It can be used, deposition testimony, to impeach the witness, but it also can be used in the same manner, my understanding, the same manner as any other discovery that's relevant and probative. So just a concern about that question that you raised. But if I'm out of order,
that's why I want
yes.
to take my time,
Okay.
Mr. Gould,
Thank you.
and think about this. Because of my non-familiarity, at least in the recent past, of not seeing it as a definitive exhibit. Okay.
Thank you.
Uh-huh. Okay, back to let's see. Well, NM area had no questions for Mr. Sandberg, nor did WRA. Oh, well, I'm going in the wrong order anyway. Amera proposed 20 minutes of cross-examination for Mr. Sandberg. Mr. Dome?
Thank you, Madam Hearing Examiner. Good afternoon, Mr. Sandberg. How are you?
Afternoon. A little under the weather with a cold. Sorry.
Well, I will.
If my voice does not come through, please tell me. I'm a little froggy today.
It's good right now, sir.
Okay.
Mr. Sandberg, I would like to focus much of what I'm going to ask you about on page 12 of your testimony. Do you have that in front of you?
It is on the other screen, so let me scroll to page 12. I'm on 12.
Great. And before we get into that, can I ask you, have you had a chance to observe much of the hearing over the last week?
That depends on the word much. I listened and watched. Well, no, I wasn't trying to be facetious.
No.
A good chunk of Mr. Baudier, and I think I probably had a total of about 4 hours spaced through the week, of which he was the bulk.
Mr. Baudier was the bulk of that?
Yes, sir.
Did you get a chance to observe Ms. Hunt at all?
No, I did not.
All right. And anybody else? Did you observe anybody else?
I'm trying to remember who came later in the week. No, I'm sorry, I don't recall. It was like Thursday of that week.
It's a fog to me too, so I don't remember who all came after those two. So, but looking at page 12 of your testimony, I would like to focus on lines 20, 21, and 22. And could you go ahead and just read that sentence into the record for us, please, starting with "it appears."
It appears, from all I've observed in this case, that for Amera and BCP, this was a business deal void of any concern for or consideration of NMGC customers.
The word that you use is void of any concern for or consideration of the NMGC customers. Can you tell me what you mean by the word void in that sentence?
That the primary concern was a financial transaction. The primary concern was the dollar value, and that concerns about NMGC customers were not on that list.
So the word void, and I understand what you're saying. You're saying that and you have that up above on that page. You have there that the primary concern was the price, and you had that quote in there. So I see where you say that, but I'm asking you, the word void, did you mean to imply that there was no consideration of customers, as that word is commonly defined?
Yes.
So you meant it like the common definition of an empty space or lacking any content, hollowness. You meant it as the word void. Is that correct?
Yes.
Miss Hutt, when she testified, and I'll paraphrase for you her testimony on pages 909 and 910 of volume 4 of the preliminary transcript that I've got here. And I just want to know if you agree with what she's saying here. First and foremost, when New Mexico Gas was introduced as an opportunity, it was introduced as a public utility. Therefore, it is explicit that the New Mexico Gas Company's purpose is to serve its customers in New Mexico, and all the bidders fully understood that. That's what her testimony was. Do you agree with what she's saying there, that there was no confusion, that New Mexico Gas Company was a public utility and that's what was being sold?
Since I wasn't involved in any of those discussions, I could neither agree nor disagree with her.
In your exhibits, you have CKS 5. Do you have that in front of you?
I do, but I apologize. It's a long single PDF. So
I will tell you, sir, that CKS 5 starts at page 127 of 506 in that PDF.
Thank you. I appreciate that.
You're welcome.
Oops. The one downside to electronic.
Yes, it is. That's why I have paper.
I'm sorry. Exhibit 4 or exhibit 5? I'm sorry.
Exhibit 5.
5. Okay, I'm almost there.
Page 127 of 506.
Yeah, you're
And identify for the record, Mr. Dummy, what it is, please.
Madam Hearing Center, I will. In Exhibit 5, there are several documents. The first 7 pages is what is called the teaser. The next 90 pages is what's called the confidential information memorandum. Then starting on page 224 is how I've got it in my notes, are some fireside chats. And starting on page 241, a management report. And I will indicate for the record that this whole exhibit is in response to a question NAE 2-43, which asked for the parties, the joint applicants, to identify the multiple parties that expressed interest in possible acquisition and provide all communications between or among the joint applicants and these parties. So these are the documents which reflect the communications among the joint applicants and the parties that expressed an interest in the transaction. Mr. Sandberg, are you there yet on CKS 5?
You have page numbers for the PDF that I don't know that I have. But let me go back up a bit.
Yeah, I feel. Yeah,
God.
but it wasn't building out.
I think there's some discussion in the background. This is hearing examiner Schaefer that's coming through from somebody's mic.
It's probably mine. Maintenance for the tornado over my head. I will mute.
Mr. Sandberg, I'll tell you what,
I apologize just because the length of the document and what we're talking about. I'm go ahead. I'm sorry.
Mr. Sandberg, I only have 20 minutes and I can't, I would, so let me just indicate to you that in those documents, and subject to check but the documents are in the record, they're in your exhibit. On page 2 of the teaser, New Mexico Gas Company is identified as the largest gas utility in the state of New Mexico, quotes, and quotes, it is 100% regulated, and quotes, it is 546 customers in the state of New Mexico. Do you have any reason to disagree with my representation of what's on that page?
I'm looking at that page also has a map showing the layout of the pipeline system.
Right.
Yeah,
so
we're on the same page.
Okay, great. Okay. So it identifies it as a utility, correct?
I'm sorry, gentlemen. One at a time.
Right. So it identifies it as a gas utility, correct?
It does.
That is regulated by the PRC, correct?
I'm looking for that statement. I don't see that on the page.
Well, it says it's 100% regulated, correct?
Yes.
Okay. Is it fair to say that anyone that was looking to buy this asset would have, by reading that communication and others in that deck, that they were going to be buying a regulated public utility?
I assume they could have figured that out, yes.
Well, Mr. Sandberg, in your testimony, you cite to the 6-factor test, and this is on page 14 of your testimony.
Are we done with the exhibit? I'll move back.
Yeah, I think you can close that off.
Okay, thank you.
You cite to the 6-factor test on page 14 of your testimony, correct?
I am there, yes. And
you are just an expert in this case. You are not contemplating buying this asset, are you?
To the best of my knowledge, I have not made an investment in any of the joint applicants.
Right. You're a lawyer, you practiced for 45 years, and in this case, when you were asked to be an expert, the one thing you did was you went and found what was the standard for approval of this transaction, didn't you?
Yes, sir.
And do you think that the entities that were buying this asset would have done the same thing?
I have no idea.
Well, if you were their lawyer and you're a lawyer for 45 years, would you have advised them to find out what the standard is for buying a regulated utility in the state of New Mexico?
I think at some point that question would have been asked and answered.
You would have advised them to look that up, wouldn't you?
It would depend at what stage of the process I was being asked to come in on.
All right.
Something, yeah.
In your testimony, you state on page 14 that you found the 6-factor test by looking at the case number 20-0222, which identifies the following factors and satisfies the test in 62-16-13. Isn't that correct?
Lines 11 to 15, yes.
And the 62-6-13 does not contain the six-factor test, does it?
No, I believe that the case, the 20-00222 UT case was interpreting the underlying statute and deriving from the underlying statute those six factors.
Right. The statute says public interest, and then the six-factor test is the way to apply that public interest standard. Isn't that correct?
I believe that is the way it's being used, yes.
When Ms. Hutt says that all the parties she was talking to knew that they were buying a utility, and she says that based on that, everyone understood that they would have to satisfy the regulatory authority in buying this utility, you have no reason to disagree with that, do you?
I cannot, as I said a minute ago, I wasn't in those conversations. I can't agree or disagree.
Okay. In CKS2, which is in your exhibits, could you turn to that, please?
I'm going there now.
Now, that's a shorter document.
Agreed.
And look at page 7 of that, if you would, please, for me.
I will scroll down page 9.
And I'm looking at it's 7 of 70.
Yeah, beginning an overview of round 1.
Yes, that's it. That's exactly it. And
And
that overview of round 1 consists of 3 pages. Well, I'm looking at pages 7, 8, and 9, which is 3 pages of that exhibit. And do you understand that to be the overview of the 5 indicative proposals that were received?
2, 3, 4. I do see 5 different names. That makes sense, yes.
And down 4 lines down on that, or 4 rows down on that, is the phrase management and employees, correct?
It appears on all 3 pages, yes.
And is it your understanding that that's because one of the parts of the bids that they were receiving that Amera was analyzing was how the bidders would deal with management and employees of New Mexico Gas Company?
I think that's a reasonable interpretation of the document, these 3 pages. Yeah.
And that's what Ms. Hutt testified to in her testimony, just for your information. So,
Objection to that commentary if there's not a question pending.
Mr. Sandberg, in your testimony, you say on page
Judge, just a moment. Can I have a really short break? It's very important.
Yes, Mr. Lee. We're in recess.
Thank you. I apologize. There's a family emergency.
Apologies. No apologies necessary. Take your time.
With Hearing Examiner Hirsch, you're muted if you're trying to address us.
Thank you, Mr. Freeman. As I said, some people like it that way. Let's take a 10-minute recess. We'll come back and see if Mr. Lee is available at that point. So it is 1:54. Let's come back at 2:04. Thank you. Remember, the YouTube is on.
I'm back, Judge. Sorry, gentlemen.
No apologies necessary, Mr. Lee. We hope everything's all right.
My mother-in-law has just been announced that she's reaching a terminal disposition.
Oh, so very sorry.
I'm ready when you are, Judge.
Very well. I stopped your time, Mr. Dome.
Thank you, ma'am. Otherwise, I'd be way over by now.
Yeah, you're right about 13 minutes right now.
Okay.
14 just tripped over. Go ahead, sir.
So, Mr. Sandberg, when you look at CKS2, and you see that one of the items listed there is management and employees, does that to you look like there was some consideration of utility customers throughout this process?
We cannot hear you, Mr. Sandberg.
Mr. Sandberg, I can't hear you. Yeah.
Mr. Sandberg, did we lose you? Ms. Nasi, what's going on?
I don't see Miss Nanasi.
Isn't she down in the lower left hand on my new energy economy?
I agree. Sorry.
Not present.
Did we lose our witness? Well, let me try to admit him again. Hello there, Mr. Sandberg. Can you hear me, sir? We can't hear you.
Madam Hearing Examiner, I just texted Mariel and she texted me back, said 30 seconds.
Okay.
She expects to be back on. Thank you.
Excuse me, Madam Hearing Examiner.
Hi, Miss Nasi, what's happening?
We are ready to go forward.
Okay, Mr. Sandberg, you can hear me? I can't hear you. Ms. Nasi, is this something we can fix?
I'm sure it is, but he's about 50 miles from me, so I can't be the one to fix it.
Does he know we can't hear him?
Yes, he knows. He's trying to fix it.
Always keep a claw hammer in my desk for that particular reason. Back when I used to have a desk. Haven't had one for a while, but
Mr. Sandberg, do you want to log off and then log back on? We can't hear you.
Mr. Lee, is it too early for our afternoon break?
No, ma'am.
Why don't we go ahead and take our afternoon break? We'll come back at 2:30 and see if Mr. Sandberg's figured out his technical difficulties. I suggest if he has not, that we go ahead and call the staff witnesses, Mr. Zigich and Mr. Tupler, at that point, and try later with Mr. Sandberg. We're recessed until 2:30. Remember, the YouTube will still be on. Thank you.
Chris, why don't you hang up and then hopefully somebody can let you back in. Can you try that?
Miss Nanasi, there may be a call-in number, perhaps if the judge and the parties will allow him to appear just by voice. That's just a suggestion.
Oh, wait, did you just get back on, Chris?
I can see and hear Mr. Sandberg, Miss Nana.
You can hear him?
I just heard him, yes, brief.
How about right now?
Yes, now it's perfect. Okay, good.
Okay. I'm taking the AirPods out and they work. Okay. I apologize for technology.
We're at recess.
Okay, so leave it and we can go.
I'm not touching anything.
Don't touch anything. And we'll be back in 15 minutes.
I'm not touching a thing.
Okay, thanks.
Mr. Sandberg, this is a court reporter. Would you mind unmuting so I can check your sound?
I would be glad to do that. How am I coming through now?
Just fine, sir. Thank you very much.
Thank you.
I'm ready when you are, Judge.
Madam Hearing Examiner?
Okay, Mr. Lee, are we ready?
Yes, Judge.
We are. Do we have our witness back?
He thinks he's back. Mr. Lee said he heard me a minute ago.
We can hear you.
Mr. Dome,
Yes, ma'am.
you want to continue?
Yes, ma'am, sure. So,
Okay, we're back on the record from our afternoon recess. Go ahead, sir.
Mr. Sandberg, let me try to put all this back together again for us. I think it's understood that from the very beginning, New Mexico Gas Company is a utility and it's being sold, correct?
Your phrase "from the beginning," I inferred I mean from the beginning of Emera's attempt to sell.
Yes, sir.
All right.
There's no realistic confusion that this is a utility and it's for sale, correct?
I don't know. I don't know what people took those initial steps to mean. I'm sorry. I wasn't a bidder.
All right. And it's clear that as you determined and as others have determined, there's a 6-factor test for approval of the sale of a utility in New Mexico, correct?
Yes.
And factors 1 and 6 of that test involve and refer specifically to the customers of the utility, correct?
All right.
And so, and you, I think in your testimony on page 39, line 1, you say that New Mexico Gas Company operates relatively well. Do you have that testimony in front of you?
I do, and that is what I said, and I said that as a customer.
Right. And if you're selling a utility, this is a hypothetical, if you're selling your utility, and if you believe that your management is at least, as you say, relatively good, but potentially much better than that, would you not try to ensure that that management continues on?
As the seller, I wouldn't care. Once it's gone, it's gone.
As the seller in this
I get paid and I'm done.
Well, that's as the seller in this case, you know from looking at CKS 2 that the seller insisted that management and employees be considered and retained. Do you not?
Yes, I assume that's why it's one of the 8 factors on overview of round 1.
And so by doing that, they were retaining in place the high quality management that they knew operated the utility in an effort to protect customers, were they not?
I have no idea why they would choose to do that. I think it's a leap of faith, as you just tried to make. And I observe that none of the 8 criteria on overview of round 1 says anything about customers.
And if Miss Hutt says that her motivation in retaining management and employees was to keep in place the quality management to help the customers, you have no reason to disagree with that, do you?
For the 3rd or 4th time, I can neither agree nor disagree with what you said. I wasn't there.
Right. Have you had a chance to look at the benefits that are discussed in Mr. Baudier's rebuttal testimony?
I know I saw this. I've read his testimony at various times.
Right. And at the end of his rebuttal testimony, he has a table of all the customer benefits. Do you recall that testimony, that table?
Not explicitly, no. I know he was summarizing things.
Right. It's on page 48 of his testimony. Do you acknowledge that those are benefits to the customers,
No,
New Mexico Gas Company?
no, not in the sense that he's using them. Well, I'm sorry. Do you want me to go find his testimony so we can discuss this? Because I did not have any, as I read the pre-hearing order, I was supposed to be told ahead of time if there were documents that I was going to be crossed on, and I don't have any of those communications saying, get ready with these documents. I think I can go find his testimony if you want me to look at it.
Well, did you read his testimony to prepare for this hearing?
I certainly read it when he filed it.
Did you also read his rebuttal testimony when he filed it?
Yes, I did.
And I'm asking you, I'm looking at page 48 of his rebuttal testimony, and I assumed that your counsel would make that available to you. Do you have that available to you?
I'm looking at the revised filing.
This would be Mr. Bodier's rebuttal testimony.
Yeah, I do understand that.
Okay.
J.A. rebuttal, Bodier. All right. Page 48, you say?
Page 48 of his rebuttal testimony, there's a table.
Okay, I'm going there now.
Table JMB2.
I see the table.
And do you believe that those are identifying benefits to the customers of New Mexico Gas Company?
Heat New Mexico contribution comes the closest. Education and training are so diffuse that I don't believe they're a customer benefit. The customer rate credit, I think, is grossly miscalculated. It is potentially a benefit, but it's grossly miscalculated here. Rate case delay is potentially a small benefit, but it's even more grossly miscalculated here. Econ development is so diffuse that trying to call it a customer benefit strains the definition.
But you would agree
One more minute.
But you would agree that in there consist some benefits to the customers.
I agree that if rate credit, rate case delay were calculated properly, they would have a small dollar benefit.
Thank you very much, Mr. Sandberg. I'm done.
Thank you, Mr. Doman. I also believe, excuse me, that BCP applicants reserved, looks like 50 minutes for cross-examination of Mr. Sandberg.
That's correct, Your Honor. And Rick Alvidrez, I'll be conducting the cross-examination when you're ready.
Very well. I didn't know you were here today. Hello there, Mr. Alvidrez.
Good afternoon.
Go ahead, sir.
Yes. Thank you. Good afternoon, Mr. Sandberg. How are you?
Just wonderful.
I understand you're a little under the weather, so I'm sorry to hear that.
And technology is not my friend, yes.
Okay, well, I want to talk a little bit about your background before we get to the substance of things. In looking at your resume, which is attached as CKS1 to your testimony, it indicates that you own a company called Digital Art Magic LLC. Is that correct? Art owner,
Yes, sir. That's correct.
And you're a professional landscape photographer and photo educator.
Also correct.
And you're also part owner of the Albuquerque Photographers Gallery.
Yes, sir.
And your primary profession is in the photography business. Isn't that correct?
Would depend how you measure it. I make more, I think my federal income taxes this year, I'll show more income from my utility consulting work than I will from selling photographs.
But you spend more time on the photographic side of the business of your endeavors. Isn't that correct?
Be close, Matt. It'd be a close call.
Okay. Well, in most years, is it not correct that you spend more time on your photography endeavors as opposed to your utility consulting endeavors?
It has over the last 7 years, it's varied from year to year.
Okay. And your undergraduate degree is in English and theater, isn't that correct?
With the secondary education certification, yes.
Okay.
I'm sorry, with the secondary education?
Certification.
Thank you.
And you list 2324 14th Street, Rio Rancho as your business address in your testimony, right?
I do.
And that's also your home address, correct?
That is correct.
Now, if we go to page 7, beginning at line 7, you list 7 cases, including this one, where you have provided testimony before the NMPRC, correct?
Yes.
Okay. And in each of those cases, all of those cases involve testimony on behalf of New Energy Economies that we sometimes refer to as NEE, correct?
Yes.
And you haven't ever testified on behalf of any other entity besides NEE in any cases before the commission, correct?
Correct.
And you've been in New Mexico a bit over 7 years, right?
Just about hit 8, yes.
Okay. And during that 8-year time period, you haven't testified for any entity other than NEE, correct?
Objection asked and answered.
Well, this was more broad. I didn't ask about just before the commission.
I'm sorry, maybe I misheard the question. Can you try again?
Yes, during the nearly 8 years you've been here, you haven't testified for any other entity besides NEE, correct?
Testified as in any proceeding anywhere.
In New Mexico.
New Mexico. Testified, no.
And on pages 8 through 10 of your testimony, you list cases before the Minnesota Public Utility Commission involving mergers and acquisitions.
That is correct.
But you weren't a witness in any one of those cases. Isn't that also true?
I was not.
And this is the only utility acquisition case involving a private equity firm where you've been a witness, right?
This is the first one.
And in fact, you've never been involved in a utility private equity acquisition case other than this one, right?
No.
So let us go to page 12, beginning at line 10 of your testimony.
Okay.
You there?
I am.
And you state at line 10, there is no mention of a net benefit for NMGC customers or the public interest whatsoever in the memorialization of the 6-month decision-making process. Did I read that correctly?
I think you did.
And the memorialization that you're talking about is Exhibit CKS 2, right? Which talks about the bid process and bid summaries, right?
Yes, or whatever exhibit we were just discussing with the previous cross-exam. I lost track of those 2 or 3.
Yeah, there were a few exhibits, but
yeah.
Let's focus on Exhibit 2 to your testimony. Can you look at page 46, 46 of 70 in that?
33, 42, 40. I'm at 46.
Okay. So the third paragraph down, beginning unfortunately, do you see that?
5 phase 1 proposals.
Well, this is
is that the right line?
No, it's page 46 of 70. And
oh, I'm sorry. The page number's at the bottom of the page, not the top. My mistake. No, Project 1 transaction impact.
No, we're looking at the top of the page where it goes page 40 of 70, 46 of 70 in this case.
Okay. I believe I am. It has 4 bullet points and some blue blobs across the bottom.
Well, not my exhibit two.
What's the internal page number?
I don't know what you mean by
22, 21?
it's your exhibit JKS2,
Okay.
which is JA Exhibit NMDOJ 1-37 third revised. You have that?
Uh, 46.
If I may, it's page 96 of 506.
Yeah, that's where I see where I was misguided here. Okay. All right. Well, I'm at page 96 of 506.
And you see the third paragraph down, beginning with the word unfortunately.
Actually, I do see the paragraph beginning, unfortunately.
And can you read that into the record?
Unfortunately, comma, and as you heard in May, comma, Saturn is a different story, semicolon. It is impossible we will execute, it is improbable we will execute a sale, period. While we did receive one round 2 offer, comma, it did not meet our value threshold and contemplated a shifting of risk by way of the change of control of regulatory concessions, parens, net customer benefit test, close parens, to us versus the buyer. This concept is entirely unacceptable and frankly out of market. Based on in-person principal-to-TO-principal meetings, yesterday with that party, comma, even setting aside the regulatory issue, comma, discussions concluded with a meaningful value gap that appears unlikely to close.
So you see that the net benefit customer test is specifically referenced in this document, correct?
I see those words.
Okay. Now let's look at page 50 of 70.
Project Saturn update.
Yes, sir. And if you go down to it's the 5th bullet point, it's indented in. Do you see that?
The non-conforming.
The sentence begins non-conforming. And do you see the second to last and last line of that that parenthetical has language in parentheses?
I do.
Can you read the language in parentheses into the record?
Noting the approval standard in New Mexico is a, open quotes, net benefit, close quotes, to ratepayers, period.
Okay. And let us go to page 62 of your testimony.
Of this exhibit.
Same exhibit. I'm sorry, I said page 62 of your testimony. It's the same exhibit, the JKS2.
Yeah, okay. All right.
And you see under the heading key risks, and then there's regulatory.
Yes, I do.
And the first bullet, can you read that into the record?
The New Mexico PRC approval standard for change of control is a net benefit test, comma, where the buyer must demonstrate a net benefit from the transaction, comma, a higher bar than in many other jurisdictions, period. Common concessions include rate stay dash outs, comma, restrictions on investment hold period, comma, or other economic benefits like economic development funding and job creation, period.
So your testimony on page 12, beginning at line 10, that there is no mention of net benefit for New Mexico customers is incorrect.
No.
Well, certainly CKS2 makes numerous references to the net benefit test for customers, does it not?
I believe that document is an internal document within. Well, let me, rather than make that mistake, let's go back and look at the top of that document. So this is an internal document being used to analyze on the behalf of the seller a number of proposals by potential buyers. Nothing in the analysis at the beginning of this document where you actually show what potential buyers came in response has anything to do with customers. It is encouraging that at least within the selling party, that they did recognize that the commission had standards, but nothing in the promotional materials that I have seen suggests that that was a point being not even emphasized, but not even thought about in the discussions with those potential buyers.
Well, isn't it true that these show that the buyers and sellers were talking about the net benefits test in the context of the bidding process?
Objection, Marilyn Assey.
On what basis?
Pure speculation. How does Mr. Sandberg know what Emera communicated to the potential bidders?
May I respond?
Yes, sir.
And I just had him read into the record, summaries of conversations and negotiations with the parties where they specifically talked about the net benefit test.
Objection, that is not correct what Mr. Alvidrez just said. And Mr. Sandberg explained it. This was an internal document. There's no evidence. As a matter of fact, it's contrary to what Mr. Alvidrez said, that there was conversations about the net public benefit or the public interest between Emera and bidders. There's only conversation internally.
I think the specific question, I'm going to overrule the objection. I believe the specific question was, wasn't it true that these show that the buyers and sellers were talking about the net benefits test in the context of the bidding process? And the witness has said that it's an internal document being used to analyze on behalf of the seller a number of proposals by potential buyers. So I think, Mr. Sandberg, you can answer the question if you know, sir.
I don't see what counsel is suggesting is there, that there was, all I see is that Emera was apparently well advised by its advisors, presumably its legal advisors, that there was a 6-factor test, and one of them was net customer benefit.
So let me have you go to page 10 of your exhibit, CKS 2. That's 10 of 70.
Oops, went back too far. That was 4, 7, 8, 9. Top 10 diligence questions?
Yes. And it says based on check-in calls, fireside chats, and diligence Q&A, right?
Based on, yes.
Okay. And under the heading regulatory, the third bullet, can you read that into the record?
What what concessions are likely to be required by the commission to approve this transaction? Question mark. Open parens. Small e period, small g period, customer credits, rate freezes, minimum holding periods, comma, local capital B board, close parens.
So this confirms that there were discussions during the check-in calls, the fireside chats, and the due diligence by prospective bidders about what benefits are going to be required for customers, does it not?
It's interesting that you phrase the question that way when that is not the way it's phrased in the bullet point. The bullet point phrases it as concessions, i.e. a financial analysis of what would have to be done to grease the wheels for a proposed transaction. Listing out what the commission might have required in other cases, again, I think it's a huge leap to suggest that there was an actual consideration of customer benefit, particularly in the context of the commission's requirement that there be an improvement as a result of the transaction.
But you agree that such things as customer credits, rate freezes, minimum holding periods, and a local board can all be beneficial to customers, correct?
They are often presented that way, yes.
Okay. Moving on to page 13 of your testimony, lines 9 through 11.
Give me a sec. I'm there.
So at page 9, you talk about BCP should put up a multi-million-dollar performance bond to be managed by the commission to ensure that ratepayers will be protected from foreseeable risk.
Yes, sir. Yes, sir.
What BCP entity or entities are you referencing there?
Given the convoluted structure of the acquiring parties, I intended to use BCP as a wraparound term for those that would actually be in the ownership and holding chain. I don't know ultimately at the point of closing where those parties will shake out.
Have you not looked at any of the transaction documents in this case, which confirm who's buying what from whom?
I have attempted to sort through those, yes.
But you don't have an understanding based after your review.
Your question about line 9, I'm sorry I wasn't clear in my first answer. I intended BCP to be a term encompassing the buying parties.
Okay.
Perhaps I should have said the joint applicants on the buyer's side.
Okay. And no other utility acquisition case in New Mexico has ever adopted such a bonding requirement. Isn't that true?
No other case. Well, in the Avangrid P&M case, there was an agreed upon settlement among all the parties, which included service standards and penalties to avoid degradation. If you're going to put penalties in, you need some enforcement mechanism. I don't think that I do not know that New Mexico has explicitly coupled along with standards and penalties a performance requirement. North Carolina, Texas, South Carolina, and Arizona have done so.
I ask you about a bond, though.
Yeah, a performance bond, yes, sir.
Okay, and Avangrid didn't involve a performance bond at all, did it? There was no proposal for a bond in that case, correct?
It didn't get to that stage, no.
And on page 23, beginning at line 13, or ask about your recommendations with respect to this bond, correct?
Yes, sir.
And beyond stating that a multi-million-dollar bond should be posted, you don't recommend any specific bond amount. Isn't that correct?
Correct.
And nor do you identify any specific service standards that you recommend be applied in administering the bond, correct?
Given the testimony of commission staff on the issue of service quality, as I say at lines 19 and 20, I'm comfortable deferring to the commission on the specifics of how they would impose and enforce service standards.
But my question to you is, you don't make any recommendation in that regard other than deferring to the commission and staff, right?
Agreed.
And you don't know the specific service standards that are applied to New Mexico Gas Company, do you?
Not at that level of detail, not at a high level of detail, no.
And you don't have any recommendations about how compliance with the service standards is to be determined. Isn't that correct?
I do not.
And you don't state the legal authority for the commission to require such a bond, do you?
Given that the commission has authority to ensure reasonable and reliable service from all of its regulated utilities, this is just one tool to accomplish that statutory requirement. I mean, the commission is obliged to do it.
But nowhere in the Public Utility Act does it authorize the commission to require a utility to post a bond, is there?
I'm not aware of an explicit requirement.
Okay, but the commission does have the authority to investigate a utility if service standards are not met. Isn't that correct?
I believe that's a good quote.
And the commission can impose specified monetary penalties if applicable commission orders, rules, or statutes are violated. Isn't that correct?
I believe that is true.
And the commission can ask the New Mexico Attorney General to file suit and seek injunctive relief to require a utility to comply with commission orders, rules, and statutes. Isn't that also correct?
I believe that's also true.
So let's go back to page 12, and we've had a little bit of discussion in the objection portion, but page 12 on line 14.
Okay. There.
Now there you are quoting from the deposition of Mr. Baudier, which is attached as Exhibit CKS 3 to your testimony, correct?
That's where the quote came from.
And you say price was clearly the most contentious issue, right?
That's what I said at 14 and 15.
But isn't it true that you omit the next line where in the Baudier testimony, in the Baudier deposition, where he clarified that he didn't want to say that it was contentious, but that they had to understand what standing up New Mexico Gas actually meant, because it was unclear. And we can go to Exhibit 3.
Objection, Mary Lanassi. The next line says what Mr. Alvidra said, which is on line 16. The only other issue was understanding what standing up the utility actually meant.
So what's your objection, Ms. Nanasi?
That he's trying to confuse the witness and say and accuse him of not including something that is on the very next line of his testimony.
Well, I've offered to have him look at his own exhibit. This is his exhibit. And we can get into it. But what has been represented is that price was the only issue, right? That's what NE's position is. In this transaction, price was the only issue.
Sorry.
Is that correct?
I'm
Go
not
ahead,
sure.
Mr. Sandberg.
I'm not sure if that was a question to me or to any council. I'm sorry.
What's a question to you?
No, I'm, I don't even, I think Mr. Alvidrez is trying to address the objection by going back and asking you what the question was. This is your exhibit, and he's asking you about your testimony.
Well, the testimony that Mr. Baudier gave was that price was the most contentious one, and I have no clue what stand up means in the next sentence, but I don't think it has anything to do with customers. But I took him at his word when Mr. Baudier testified that price was clearly the most contentious issue. And to me, the contentious issues are the important ones.
But why didn't you go ahead and include the rest of his answer?
Because it doesn't add anything to the first sentence. He sort of rambles on about we were getting a fully functioning utility, had to understand what stand up meant. I could not discern any meaningful issues in the follow on sentence. The first sentence was quite clear.
Mr. Alvidrez?
Yes. Well, but then, as the hearing examiner pointed out, he retracted that and said, I don't want to say that it was contentious, right?
I don't, when you say it's the most contentious, and then I don't want to say it was contentious, I think he meant what he said in the first sentence.
So if we go down to page 22 of this, line 22, I'm sorry, he says, and I wouldn't say that like there was a contentious negotiation around it, but there was a better understanding of what the kind of situation was with the shared services. Do you see that?
I do.
And
also a financial issue, yes.
And you didn't include any of that in your testimony. You went with the single sentence.
Objection to the form of the question. He did include it because it's part of his exhibit.
I'll rephrase the question. You didn't quote any of that in your testimony, did you?
I did not. I quoted what he said was the most contentious, and I agree. I am using the word contentious in my opinion, contentious is the important issues. And when you say it's the most contentious, anything else falls behind it.
So any type of the rest of the answer you don't think was important? Mr. Zandberg?
Yeah, I'm sorry, Your Honor. I was going back and trying to read the rest of that long paragraph. It's rather confused and rambling, and B, I do see that he also mentioned shared services, which is another financial, i.e. pricing issue.
Go ahead, Mr. Alvidrez.
Yes. Let me jump to pages 25 through 30 of your testimony.
Yeah, give me a sec to scroll back. Oops. I'm at page 25.
Okay. And on page 25 through 30, just a 30,000 foot level, you discuss a number of articles that you claim address the harms of private equity ownership, correct?
I do not claim they address, they do in fact address.
Well, I should rephrase that these are articles addressing claimed harms of private equity ownership, correct?
I'm sorry, they had articles addressing, I missed a word there.
Yes, claimed harms of private equity ownership, correct?
I would have used the word demonstrated harms.
Okay. In any case, you cite to a number of articles
I do.
that are attached as exhibits 7, 9, 10, 11, 12, 13, and 14 of your testimony, correct?
I'm scrolling down to check the numbers. That looks right, yes.
And you did not author any of those articles, right?
I did not.
And you didn't participate in the preparation of any of those articles, right?
I did not.
And none of those articles address public utility ownership by private equity firms. Isn't that also correct?
They do not.
And you don't know how many utility companies on a national level are owned by private equity firms, correct?
Sitting here today, I do not.
And on page 30 of your testimony, beginning at line 21 and continuing on to page 31, you address a proceeding before the New Mexico Public Utilities Commission involving the proposed acquisition of the parent company of Minnesota Power. I think it's called Elite, ALLET.
No, that is not correct. The case is pending before the Minnesota Public Utilities Commission.
If I didn't say Minnesota, I meant to. I apologize.
I inferred that as well, but for the record.
Okay. And it's by a the acquisition is by a BlackRock private equity company, correct?
I believe that's part of that family of equity, yes.
And you attach comments that were filed in that proceeding from the Minnesota Attorney General, correct?
I did.
And isn't it true that on October 3rd, 2025, the Minnesota Public Utilities Commission voted unanimously to approve that acquisition?
Excuse me, I'm sorry. Yes, there was a vote taken that day. As of earlier today, there is no commission order, so we do not know what the basis for that decision is, but there was a vote.
Okay. And you're aware that NMGC was previously owned by a private equity firm, right?
Yeah, agreed.
And you don't mention that in your testimony anywhere, do you?
I did not.
And you didn't do any research on NMGC's previous private equity ownership, correct?
I did not go back for that, no.
And you can't identify any negative consequences due to NMGC's ownership by a private equity firm, correct?
I have not attempted to do that.
Are you now aware that when El Paso Electric was a publicly traded company, that it filed for bankruptcy?
No.
Let's go to page 32 of your testimony.
I'm there.
And at page 32, beginning at line 8, you talk about El Paso Electric Company filing 2 general rate cases, one in mid-2021 and the other in early 2025, correct?
Yes, sir.
And this was after El Paso Electric was acquired by a private equity firm, right?
IIF, yes, correct.
And you indicate that with regard to the 2 cases that were filed, you say, beginning at line 9 through 10, the scope of increases sought by EPE were disturbing. You see that?
I do.
But isn't it true that there's no way to know that but for the private equity ownership of El Paso Electric, that they wouldn't have sought these rates?
I don't I don't believe there's a way to get into an alternative dimension and understand the answer. However, it certainly is the case that EPE has exceeded Texas retail rates as a general percentage.
Well, did they exceed Texas utility rates as general percentage before they were owned by a private equity firm?
The numbers I have are back to 2020. I did not try to go back prior to 2020.
Okay, so you don't know whether they're higher now than they were when El Paso Electric was a publicly traded company, correct?
Oh, I do know they're higher now, yes.
Well, I mean, as relative to other Texas utilities.
No.
But getting back to my question, that is that you can't attribute these the increases that El Paso Electric sought in these two rate cases to their status as being owned by a private equity firm, right?
I can't attribute it.
Right.
No, but I can draw an inference that it is consistent with a pattern of private equity acquiring companies and making steps, taking actions to increase revenues. So yes, I infer it's a common illustration. I'm sorry, it's an illustration of a common private equity approach.
So do you remember giving your deposition in this case on May 6, 2025?
I do.
So on page 92 of your deposition, you were asked the question, okay, so are you telling us that but for the private equity ownership of El Paso Electric, they wouldn't have sought a rate increase? Your answer, no way to know. Question, so you don't know? Answer, there's no way anyone can know. Is that your testimony on May 6, 2025?
It was, and it, as I said a minute ago, without going to an alternative dimension, we cannot know.
So let's talk a little bit about the El Paso Electric case that you've included. You provide an order, CKS 18, correct?
From the 52195 case, yeah.
So can you go to that?
Sure. That one usually stands out because of the cover page. I'm there.
So I'm going to also ask you to look at your testimony at page 32, line 11.
I'm sorry. Where do you want you want me to be two different places? What are we doing?
Well, do you work at page 32, line 11? You indicate that EPE, El Paso Electric, sought a $69.7 million Texas jurisdictional retail rate increase in base, non-fuel, and other miscellaneous revenues, right?
Which I got from the first page of that commission order.
Okay. But isn't it true that the net increase that was actually requested was $41.8 million?
There was going on to the second page of the commission order, there's a reference to whether El Paso was already recovering through apparently a tracking mechanism or two tracking mechanisms. I'm not arguing about what the commission said in its order, but I did quote the fact that it was a 69.7 non-fuel revenue requirement increase.
But the net, my question to you was, the net was $41.8 million, right?
Paragraph 6 says the requested net increase to base revenues is 41.8.
So let's look at page 11 of this same order.
So,
Do you see the heading rate case expenses?
I'm getting there. I do.
And you see paragraph 88, it says the signatories agree to remove rate case expenses in the amount of $4,087,168 from base rates.
I do see that, yes. It's not unusual to have that issue raised and fought over in a case.
And that $4 million in round numbers was part of the $41.8 million deficiency, right?
I don't know where that fell on either side of of paragraphs 5 and 6's differentiating factor. It does say that it was part of the rate request.
And in paragraph 87, it says that the signatories in that rate case agreed that 4.3 in round numbers for $4.3 million would be recovered through a separate rider over a 4-year period, and that it was not included in the agreed base rate revenue requirement, right?
That's what it says.
So that money was recovered outside of the $5.1 million settlement amount, correct?
Fair question of how Texas computes those. I don't know.
So, and in fact, you really don't know too much about this case, right? Other than you read this order.
Agreed.
And you would agree that there are many elements to the settlement of this rate case, right?
As is almost always the case, yes.
And you don't know the value to El Paso Electric. Certain of these things, such as the agreements around excess deferred income taxes or relate back surcharge and things of those nature that were also settled in the context.
I'm sorry, after excise taxes, what did you mention?
I also,
Didn't hear.
yes, I mentioned relate back surcharge.
Go ahead.
So you don't know what the value of those elements of this settlement were to El Paso Electric, correct?
I take this as a black box settlement where those figures were not disclosed, period, much less in the order.
Does it say it was a black box settlement?
Well, it gets to the end and says, here's the number.
Well, there are also attachments, are there not, that you did not include?
I don't know.
Okay. Well, I'll move on from this topic, but let's look at pages 18 to 20 of your testimony.
Give me a sec.
You're at 5 minutes, Mr. Alvidrez.
I'm at page 18.
Okay, and beginning at line 14,
Yes.
continuing on to page 20, you provide a list of benefits based on Exhibit 1 to the joint applicant's application, correct?
Yeah, revised executive summary exhibits, yes.
And this is not a full list of all of the benefits and regulatory commitments that the joint applicants are proposing in this case, correct?
As I say on page 20 at lines 7 to 8, there are other commitments which I lumped together and discussed later.
And the listing here isn't a verbatim statement of what the commitments are, correct?
To the best of my ability, they were faithful summaries.
Okay. And you indicate that you segregated your list into 3 categories, right?
I did.
And the first category that you describe has to do with benefits that you claim do not depend on the change of ownership, right?
That is correct.
And on page 20, line 15, you denominate those as benefits 1, 2, 3, you say 4 in part, 5, 6, 8, 9, 10, 11, 12, and 13, correct?
That's what I wrote.
So let's look at the economic benefit with regard to economic development.
All right.
So you would agree that NMGC is currently under no obligation to spend any funds on economic development, right?
Obligation? Not that I'm aware of.
Okay, and if the transaction is denied, NMGC would still not be under any obligation to spend any funds on economic development, correct?
NMGC would continue to have the option to spend on economic development as it seemed appropriate.
And it would also have the option not to spend, right?
0 is one of the options.
Okay, but if this transaction is approved with the proposals that have been made by the joint applicants, NMGC would be under an affirmative obligation to spend $10 million in total on economic development, right?
Yes.
And
but they could do it without a commission order right now. That's the point. They don't need this transaction to say, hey, it'd be good for the state of New Mexico if we kickstarted some economic development. That their board could say that is a good thing for us to do and do it tomorrow. That's the point of this category, is not that they are obliged to do things, but they are all things that could be chosen to do. So saying that they somehow arise out of the transaction really misses the point.
But the converse is that they can choose not to do these things, right?
Surely.
And but with the transaction, they have to do these things, right? If the transaction is approved with the regulatory commitments, they would be under a legal obligation to do these things, right?
I won't quibble with your use of the phrase legal obligation, since I'm not a practicing lawyer, but they would certainly have committed to them. What happens after that, we would have to wait and see.
And likewise, there's no obligation for New Mexico Gas to provide a rate credit for customers, correct?
That is absolutely correct. It is a choice they could make, but it's a choice.
They couldn't do it unilaterally, right? They would have to get commission approval to do it, right?
I believe a rate reduction case would probably be one of the faster resolved cases before the commission.
Even if it impaired their ability to make capital investments, you think that would fly?
One assumes that they're not that foolish.
Okay.
Got a minute, Mr. Alvidrez.
So do you know how much the $22.4 million represents on a over the 12 months for the average residential customer?
Well, I have an idea, but let me make sure I don't misstate it. I'm unclear at this point because of having seen only some of the first week of hearings, that there may be an agreement to go to a per capita allocation of those rate credits as opposed to volumetric, or it may be that there is a partial per capita and partial volumetric. Having explained that lack of clarity to me, I believe it. Either way they do it, for average res, it's under $2.
Under $2 a year? I mean, yeah, under $2 a year.
No, I'm sorry. Those numbers have floated back and forth enough times that I'm not willing to. I would have to go back and double check that. I do not have it in my head.
Okay, thank you very much, Mr. Sandberg.
Thank you, Mr. Alvidrez. I believe that's all of the parties that had reserved time for cross-examination for Mr. Sandberg. Sir, I have a few questions for you.
And I was hoping you were telling it earlier that the amount of cross-exam time was slipping away. That was what kept me going for the afternoon.
I apologize for that. We started off, I don't know if you were available this morning, but in an area, I'd gotten an email yesterday where they waived the cross of staff witnesses. So
I'm glad to respond to the best of my ability to your questions.
I appreciate that. I noticed in your background that I guess before you were in law school, you worked for the Minnesota Public Utility Commission?
I hope that's not the sequence that comes out of what's written. Between undergrad and law school, I worked for what was then Northwestern Bell Telephone Company, which was at that time the largest regulated telco in the state of Minnesota. But I was an employee of Northwestern Bell.
Okay. And I guess I'm referring to page 2, after you worked at Northwestern Bell.
Yeah.
And it says you started law school and at the beginning of the second year in the fall, took a position at MPSC. Who is MPSC?
At the time, that was the Minnesota Public Service Commission, the name of which was changed a couple of years later to the Minnesota Public Utilities Commission.
And I thought it was really interesting that they didn't have a staff.
It may well be a unique
I don't know. I seem to recall years ago at a attorney conference that actually there were some other commissions that but they had a lawyer. I don't know that they had a staff. But then on the next page, so you're talking about the work that you did, and then on page 3 at line 8, we spent the next 9 months reviewing all of the general rate cases that had been decided since 1974 for gas and electric utilities, and further back for telephone companies. And then I think you go on to talk about after you pass the bar exam, that the commission in 1980 got authority and I guess probably a budget to hire its own professional staff. And then you accepted the full-time position with the Minnesota Public Service Company as its first ever staff attorney. That's correct, sir?
There's something that, Mr. Sandberg, that you did, we're not hearing you. Now we can hear you. No.
Mr. Sandberg, are you there? Ms. Nanasi, in the interest of time, do we want to attempt, I believe on the Zoom feed, there is a telephone call-in number.
I could get that. Can I, could I offer something while he's trying to get linked up for a minute?
Why don't you, you know, in the interest that he can't, or that he can hear, I'm just trying to see if this link has yeah, it says it has a join us by phone, I guess, link here on it.
Okay, let me.
I don't want to publish it over
No,
over
no,
the
no.
YouTube.
I'll get it from my
Okay.
Send it to him through the chat, Mr. Nasi. Mr. Sandberg, can you hear us? Can you raise your hand if you hear us? Okay. So you've heard the discussion. Mr. Nasi will be sending you a call-in number. Is that correct, Mr. Sandberg?
Yeah, all I have.
Now
all
we
I
can
have
hear
is
you.
Like I said, it is
Okay.
magic. There is no explanation. Ms. Hurst, I'm real sorry. I'm not trying to make this hard.
Okay. No, I'm just, you know, saying, talking about your experience, that you were the first ever staff attorney, and you did that for about 3 years, right?
Yes, ma'am.
Okay. And then you went to the Attorney General's office as an attorney for the utility division, and then the manager of that division,
Yes,
correct?
ma'am. That's correct.
Okay. And you did that for about 6 years?
Yes, ma'am.
Okay. And I think you testified in response to either Mr. Dome or Mr. Alvidrez that this is your first private equity case as a witness. Is that right?
Yes, ma'am.
But you've indicated that you had experience in other private equity acquisition cases?
The cases that I listed out on pages 8 and 10 kind of run the gamut. Some were large and public companies. Quite a few were privately held companies, not public in any way. Whether they would fit with the current definition of private equity, I'm not sure that they would fit within private equity as it's being used in this case. But a lot of them were privately held, closely held buyers and or sellers.
Were the majority of these telecommunications companies?
Regrettably, yes, there was an incredible amount of consolidation, particularly at one point, Minnesota had over 100 small rural telcos. And the vast majority of them were absorbed into larger regional companies. It was quite a slaughter.
I wanted to ask for a little clarification, sir, with regard to your testimony. I think that Mr. Alvidrez was just talking to you about a few minutes ago, and that's looking at your executive summary on page 11. And
Okay.
The line 11, well, on line 10, you say the key parts of my opinion are as follows. And on the line 11, you say first and foremost, the acquisition as proposed and viewed in its entirety does not provide net benefits to the public. Is that correct? The first sentence of that?
Yes, ma'am.
Okay. And then second, on line 14, you say, second, the benefits provided by the joint applicants are not significant and are outweighed by the lack of consumer protection. Correct?
Yes, ma'am.
And then third, on line 20, the asserted benefits to gas company customers are insignificant and compared to the potential harms of the acquisition, correct?
Yes, ma'am.
So it seems as if some of these are very similar. Aren't they?
I think there were three. I was trying to be as, what's the word I want? Trying to be as clear as I could and state in a couple of different formats the fact that the balancing that we're required to do here to show a net gain to customers is not present. The first and foremost is kind of the summary. The second is trying to compare insignificant with lack of protection. And there are also, leaving aside consumer protection, I think there are potential harms as well. So they are kind of three aspects of the same problem, that the balance doesn't work.
Because I guess I don't really understand the difference when you say benefits are not significant and benefits are insignificant.
There may not be a difference.
And then there's a fourth one on the next page, page 12. Fourth, the joint applicants have made clear that this acquisition produces benefits to gas companies' current owners.
Yes, ma'am.
That's your testimony, sir?
It is.
And so my question is, why, I mean, presumably, if a utility owner is selling it, wouldn't you presume that they would be doing so because they were going to benefit?
That would seem like a, excuse me, like a reasonable assumption, but I can assure you in several of the telco cases that we discussed a few minutes ago, there were essentially, it was calling them fire sales doesn't even begin to talk about the fact that the selling company just wanted to get out with some, without losing. My point here, I guess, is that we know that there is an acquisition premium. We know that there is an opportunity for Emera to get above book value. And that we also know that price was, I'm down to line 14 and on page 12, price was the most contentious issue. And I do go on to say at line 16 and 17, the only other issue was understanding what standing up the utility actually meant. I did complete the quote, just not on the page that I was being crossed on.
Well, and I'll go back and look at your testimony, but I think the implication is, Mr. Sandberg, that you weren't being quite fair in just using one part of the quote when there was further explanation on the quote. I mean, you understand that, right? I mean, you wouldn't necessarily want, if you had one sentence, you know, that said something, and then in the and then you had 14 sentences after that that were explaining the first sentence or qualifying or whatever. You wouldn't just want to be held to that one sentence, would you?
In your hypothetical, no. Here we have two sentences, and I'm not trying to quibble, but I understand exactly the point of the cross was, oh, you left out the next sentence. On that page, I did. On this page, page 12, I did not leave it out.
Okay. Well, like I say, I'll consider
Understood.
the cross-examination that actually occurred in the document, potentially the document you're being crossed on. No, my question is just about this fourth thing. It's like it seems only reasonable that somebody selling something, depending on the reasons they were selling it, would want to sell something because it was going to benefit them. And that seems reasonable to me, but yet it seems like in your testimony, you're trying to hold it against them for being reasonable. Is that what you're trying to do?
No, ma'am, I was not. I was just trying to point out that it does produce benefits to the current owners. So on that side of the equation, it's entirely clear that there are benefits flowing from the transaction. And there's nothing wrong with the seller making money, but I just want to be clear that that is the benefit.
Okay. Did you hear any of Ms. Hutt's testimony?
I'm pretty sure I did not, given the couple of quotes that were earlier. I'm almost positive I did not.
Would it surprise you, Mr. Sandberg, that, and I'm not going to try to paraphrase this because I would probably be inaccurate, but there was a whole lot of testimony on this acquisition premium, also known as, in some realms, goodwill.
Yeah.
And basically she testified that due to these impairments, that Emera was actually losing money on this transaction. It would be considered a loss because of the, I guess, the impairment on the acquisition premium. Does that surprise you?
Somewhere between surprised and confused. I'm not questioning your summarization, which I'm sure is accurate. I don't know that I understand it.
Okay. If what was presented, that the transaction as far as the acquisition premium, that the way I understood it, it was a loss, and therefore they were not going to recoup uh, necessarily the acquisition premium that had been paid. Would that change your opinion about whether or not there was a benefit to Emera?
I'm thinking back to some of the, probably from some of the discovery where I inferred that Emera really wanted to dump New Mexico gas. It no longer fit into their strategic portfolio. They weren't happy with what they projected as long-term potential results. And I have the impression, I can't point you to a particular document. I have the impression that they really wanted to unload it. So that maybe is consistent with what you're referring back to. Maybe this was the right time to take what they could get.
Okay. I don't think that answered my question, but
Oh, I'm sorry. I apologize. Could you try asking me again and I'll try to
sure.
be better?
No, I understand your thinking. I just didn't hear you say if Emera was selling gas company uh, and because of the current amount of the acquisition premium and the impairment, uh, if it was going to be logged as a loss, then does that mean anything to your characterization that Emera's getting benefits from this sale?
I think it's hard to be sure, but if I'm right that Emera really saw continuing to hold NMGC as a losing proposition, taking a hit now, if that, assuming those are the facts in your question, taking a loss now to avoid a protracted set of losses in the future might well have been a benefit. But there's a lot of there's not a great deal of clarity there for me.
Okay. I wanted to ask you a little bit about your testimony on pages 20 and 21. And I think Mr. Alvidres asked you or Mr. Dome,
I believe Mr. Alvikris.
yeah, about your characterization of some of these commitments. Did you have an opportunity, Mr. Sandberg, to review the bench request number 1, which was some listing of additional commitments
I
that
believe
that joint applicants made?
I believe I have seen that. I'm looking to see if I can put my hands on it expeditiously. I do recall it. They basically had modified or expanded, is my recollection, some of the earlier statements of those commitments. But let me see if I can put my hands on that.
And I just wondered,
Yeah, here we go. I got it. Well, I see it on the computer.
generally,
I see it.
okay, whether or not, and then I think they're working on bench request 3,
Okay.
which there were a couple more during the hearing. I think that they agreed to Um, and I didn't know if you were aware of those, but just generally, do any of these additional benefits that they agreed to in rebuttal, do they give you any more comfort with regard to the proposed transaction and what the joint applicants are willing to commit to?
Withdrawing the request for regulatory asset on its face is a positive change. Of course, that leaves open the ability for the company to come in its next rate case and ask for the same thing without having it guaranteed through a regulatory asset, but at least it takes it off the table for the time being. Extending the commitment on employees from 36 months to 60 is moving in the right direction, but it should be 120. I'd say of that list, the only one that I thought was verging on significant was pulling the regulatory asset back. That at least makes it less likely they'll get it.
What about the number 4, the joint commitment, the joint applicants commit to, at a minimum, maintaining gas company's current 5-year capital investment plan?
Scroll back to that for a second. So it basically extended from 3 to 5. Okay.
Well,
that's
no,
better.
I think it actually changed it. I mean, their commitment was a rolling 3-year average for depreciation and amortization expense on an average annual basis as needed. But now, there was testimony, I believe, from Mr. Shell that talked about how they have 5-year capital investment plans that kind of, I guess, change like every year when they look at it again. But because, well, and so so now they're committing to that 5-year capital investment plan. Do you think that's a benefit?
If your assumptions or conclusions, no disrespect intended, are correct, that it is a broader commitment, then yes, it's an improvement. And I'm not trying to quibble. I don't have in my head the current 5-year capital investment plan being differentiated from what they're currently doing on that rolling 3-year.
Okay. And I'm not trying to put words in your mouth. I just can tell you from having heard gas companies' last few rate cases, that there's been a whole lot of emphasis on things that for safety reasons have to be invested in, and other things that they'd like to invest in that might need to be invested in, like location. I think I recall hearing that ultimately safety, especially in I think investment, and when there are stipulations on a certain revenue requirement, safety's paramount as far as the investment's concerned.
Sure. And I appreciate that. I guess what concerns me is continuing a capital investment plan is different than having a reasonable amount of rate base.
And I totally understand that. But that's not what the commitment was. And
Understood.
that's what I'm asking you about. Okay. So to use your vernacular from page 21, line 7, do you think that particular one, the agreement on the infrastructure was just a Band-Aid?
Well, if given my belief that it is typical for private equity folks to come in and strip as much as they can out of existing acquisitions. Yeah, I'm very much concerned that an easy way to do that is to do the absolute minimum on things like safety. So, yeah, if bringing in a new owner with a mindset to find every possible cost saving in the short term, that is a problem. And to the extent that they patch over that with, well, at least we'll do safety. Okay, then that is a good Band-Aid.
And what evidence do you have, Mr. Sandberg, that BCP is one of these private equity folks who's going to come in and strip as much as they can out of existing acquisitions?
Given the long period of ownership of regulated utility companies measured in a few months, we don't have a track record yet.
So you can't really say that they are going to be then, can you?
I can't tell whether they will or will not. Which was why which was my point that if you put a Band-Aid on the wound, that is a good thing.
Okay. And I wanted to ask you a little bit about your testimony. I think Mr. Alvidrez asked you about the performance bond.
Yes, ma'am.
On page 23 of your testimony, lines 1 to 4.
Yes, ma'am.
That's where the question is. What is a performance bond?
That if the standards set by the commission are not met, and they find that there has been a failure to meet up to the performance, i.e. safety, reliability, repair, maintenance, then it would be my hope that financial penalties would be imposed. The purpose of a bond is if that happens and the company says, geez, we just don't have that. We really can't do, we can't pay those penalties, that there's a third party guarantor to call on. Again,
and I believe,
sorry,
go ahead, sir.
Oh, I'm done.
Okay. I thought I interrupted a pause. Okay. I believe that in your response to, can't find where I made the note. In your response to Mr. Alvidrez, you testified that if you knew of places where a performance bond had been required by the commission.
Yes, ma'am.
Or had been required, and you testified Texas, North Carolina, Arizona, and I can't remember. Tell me again, please.
Yes, ma'am. I'm scrolling down to that. North Carolina, excuse me, requires a bond for water and wastewater utilities I can give you a statutory cite for that one. It's North Carolina Statute 62-101. I'm sorry, -110.3. The Texas Commission can require a bond for an applicant for a certificate or an amendment to a certificate to ensure that continuous and adequate utility service is provided. And that's found in the PUCT rules at section 24.102. The South Carolina PSC requires a performance bond for telecom carriers doing retail local exchange services, and that's in the PSC rules, section 103-607, small a. And the Arizona Commission has the power to require performance bonds to ensure that service is proper, adequate, or sufficient. And that's in their revised statutes, section 40-321.
And what's the authority here in New Mexico that you think we have to issue?
It would have to be derived from the Commission's general powers to require reasonable and adequate service. And as Mr. Elvira's pointed out, the ways that they have explicitly to enforce that, I think that it is not beyond the pale for the Commission to say we need a backstop.
And just so I understand your testimony, on page 24, the question posed at line 1, are there other troubling aspects to the proposed transaction? You say yes, and then you reference the current IT system for gas company. Is that correct?
Yes, ma'am.
And you say at line 5, trying to count as a benefit the acquisition of a new IT system, assuming that there are actual savings and customer benefits, is not a reason which would justify the proposed transaction. Correct?
That's correct. You read it correctly.
Well, why wouldn't replacement of the new IT system be a benefit?
I think there are two reasons why it's questionable. The first is that if the current system really is a problem, then New Mexico Gas doesn't need an acquisition to make the management decision to replace and improve. The other piece that I think muddies the water terribly and makes it almost impossible to see if there is a benefit is the complete lack of a cogent analysis of the costs of options for replacing what is said to be a system that's going to go out of basically out of maintenance by the software company in short order. There has not been the sort of deep, careful examination produced by the applicants of what the better solution actually is, and it may not be the one that's being proposed by the joint applicants.
So you weren't persuaded by the testimony that the system that's currently being utilized is an electric system that's been modified to be used by a gas company that has to have, in its current version, has to be updated within a couple of years. As opposed to this going from the server-based to the cloud-based system that has been specifically engineered for use with gas utilities and is currently being used and or implemented to two other gas utilities now.
I don't disagree that it probably makes sense to, number one, get out of a system that's coming to end of life. And number two, to look at cloud-based alternatives to historic, my server sits in the closet and does things. The issue is Oracle the right place to go? I note that SAP, the other, in my mind, the other really big ERP provider, has a cloud public edition that's being used by at least one other LDC, People's Natural Gas. They've moved to SAP's cloud-based, and it's got a terrible acronym, capital S/4, capital HANA, and I have no idea what those stand for. And People's has over 600,000 customers. So there are cloud-based alternatives for gas companies that probably should all be looked at before a decision is made on what to do to get out of the current server-based system. And I see nothing in the record that says that's been done.
Sir, on pages 27, 28, and 29,
Yes, ma'am.
going on to the little page 30, your testimony concerns what you label as general detriments of private equity, and you cite several attachments in that particular testimony. And these seem to be references to medical hospital institutions.
Correct.
Is that right?
It is.
Why do you believe, and basically, you say what they are, but how do you believe they relate to this case?
They're illustrations of a pattern in the private equity world. And I chose these because these healthcare studies relate to healthcare institutions and facilities that are both capital intensive and are incredibly important to public health and welfare. And I think those characteristics are very similar to that of running an LDC, capital intensive, and people freeze when there's a problem. So the reason for using these analogs to talk about what we're already seeing as problems and detriments from private equity was designed to say, here's some warning lights about what happens when they take over critical services.
Mr. Sandberg, did you happen to hear any of Mr. Shell's testimony?
I believe I heard some of it, yes.
Did you with and what I'm thinking about is his testimony of his about rate cases. Um, did you hear him testify that gas company has been filing rate cases approximately, I think, every couple of years? And that, but for, I think, potentially, and I'm just paraphrasing, but that potentially, if there hadn't been the acquisition case, they'd be filing now.
Yes, ma'am. Excuse me, I'm sorry.
No,
Yes, ma'am, I did.
so when
I
you
won't
talk,
swear that I heard it, but I've read the transcript.
okay, so so my question, you're talking about in the next part of your testimony about, potential detrimental effects with regard to, I guess, they're, they're they're going to come in and ask for a rate case. And so, the question in my mind is, well, yeah, a gas company was going to come in and ask for a rate case anyway. So, in your equivalency of wanting to say, well, some of the benefits aren't really benefits because gas company could do those things if they really wanted to. Well, isn't this kind of, to be fair, can't you equalize out the detriment to say, well, oh, if it's under private equity, they're going to come in and ask for a rate case, knowing a gas company's already going to come in and ask for a rate case. So how's that really a detriment?
I guess I had understood the point of Mr. Shell's testimony to be focused on the idea that a deferral of a rate case was a measurable consumer benefit because your rates wouldn't go up as fast as they otherwise would if we filed sooner. So I wasn't, I was focused on his calculations of how do you come up with a benefit for deferring a rate increase, which he did testify would happen either way. But if a commitment is to not file for a period of time, and therefore that's a benefit, I had dug into his calculations of how long that deferral would actually be, and I just didn't come up with the same benefit that he did.
Right. And I just, again, just trying to be fair and looking at trying to keep the apples with the apples. It just seems like to me that if the commission accepts your view of benefits, then, that one wouldn't be a detriment since it was going to happen anyway. Isn't that fair?
I guess I wasn't trying to phrase it as a detriment. I was just focused on if there is a deferral, is the deferral a benefit?
Okay, and I guess I was looking at your testimony on page 33. The question posed at line 15 and 16, do these cases prove that gas company will seek for rate increases if the proposed acquisition is approved? And you answer no. they demonstrate that the usual pattern of private equity firms seeking to increase prices and extract additional revenues from their targets have been replicated at the post EPE post acquisition. And have there been similar rate filings? And then you go on to talk about the rate filings. So that's kind of where I was going with that. Also wanted to ask you about your testimony at page 36. And this is in response to the question posed at line 14. Do customer benefits appear in that blueprint? No, that's not the question I wanted. I want the next question. Question 16. Are there risks on the operational side to the proposed transaction? And you begin your answer on line 18 and you say, fundamentally, joint applicants have had no meaningful experience running a local distribution utility or an intra-regional natural gas pipeline. That's your testimony, sir?
It is, ma'am.
Does it make any difference to you that the persons that are actually going to be running or have operational control based on the testimony are the New Mexico gas employees that are currently running it?
It's an interesting conundrum. If in fact that is exactly what happens, everybody who's here right now continues to do everything they've been doing, then no change, no benefit, it's just business as usual. On the other hand, if the new guys come in and they do some of the concerning things that we've seen elsewhere, as you were just discussing with healthcare, and begin to push down changes to New Mexico gas, then yeah, there could be. And I don't think people buy stuff intending not to ever have any control over it.
So you're having them keep the local control and all the experience that, well, let me ask you this. Do you think New Mexico Gas is currently operating in a safe and successful manner?
I have no reason to think it is not, and I phrase it that way because I'm a customer and I'm a happy customer. I'm not aware of any recent issues that would suggest serious neglect or fault or bad management. So yes, I think, as I said in my testimony, it seems to be a pretty well-run company. And if it continues, that's great. But you can't rate continuation as an improvement. That's a real.
Well, if they go ahead, sir.
I was going to say that's a real fundamental issue with New Mexico requiring that there be a net gain. Mr. Alvitras brought up the elite case back in Minnesota. Minnesota has the opposite standard. Minnesota says, well, just you can acquire something as long as you'll make it worse. And that's very different than here. Here it has to get better.
Okay. Sir, that's all the questions that I had for you. I thank you. I appreciate your time. Hearing Examiner Schaefer, any questions from you?
Thank you, Hearing Examiner Hurst. I have no questions.
Very well. Any redirect, Ms. Nanasi?
Yes, I have just a couple of things.
Okay, go ahead.
Is the reason you suggest a performance bond is because of the lack of experience of holding a regulated gas utility?
Objection leading.
It is leading.
What is the reason you are suggesting that there be a performance bond put up?
I think it'd probably be probably two key factors. One, inexperienced, unproven ability to successfully run an LDC and pipeline. The other is the occurrence of bankruptcies within the private equity field that is at a higher rate than non-private equity companies.
Your Honor, I move to strike the last part of that answer. He's introducing new testimony, which if he wanted to get into the record and support his rationale for the bond, he should have included that in his testimony, but he did not, and now we're taken by surprise.
Ms. Nanasi? Do you know where in your witness's testimony that he testified to that?
No, but if it's his opinion in response to that question, it seems to be reasonable inference from everything else that he said. I mean, he's talked about private equity and the harms that it has caused in the medical field, and that's part of it.
Mr. Sandberg, is there anything in the articles in the medical field that relates to bankruptcies?
No.
Okay, I am going to strike that answer as non-responsive. Go ahead. That part of the answer as non-responsive, the last part. Go ahead. Anything else?
Yeah. Are there commitments? You talked about a lot with hearing examiner Hurst about the commitments that joint applicants have made. Are they, you recall that
Yes,
question?
ma'am.
Okay.
I do.
Are there commitments that would make you more comfortable with approval if they were committed to by joint applicants?
Yes.
And what would they be?
Objection, Your Honor. He's asking now, counsel is asking him to come up with new commitments. He had the opportunity again to come up with commitments if he had commitments that would make him happy. He specifically declined to do that in his testimony. And again, we're trying to introduce new evidence in this case, and we have not had a chance to respond.
Mr. Sandberg, have you had any commitments in your testimony
No, I
that
think
you have suggested that would be would assuage any of your concerns?
no, I think Mr. Vitras actually paraphrased my testimony quite accurately. And I said I would need to look at a proposed settlement or other resolution of the case and see it as a whole to know if it re-tipped the balance. I did not say this in the testimony, but I certainly have ideas about what would be good in such a wraparound settlement. But I wasn't going to spend, it was pointless to try to guess what other parties might come up with at the time we filed the testimony.
Ms. Nanasi?
Yes. Do you know how many
Wait a
years?
second. Are you going to try to defend over the objection?
Oh, I thought that you had already asked another
No,
question.
no. I just was trying to clarify in my head what was going on. So, I mean, Mr. Alvidrez is objecting, claiming this is beyond the scope.
And then you asked Mr.
And then I ask him then I ask him a question to try to clarify this. Do you believe that, or do you think your witness already answered?
I think he answered your question, and that is sufficient.
Okay, very well. Do you have anything else?
Yeah, so Mr. Sandberg, do you have any idea how long BCP has agreed to hold NMGC?
I believe it's still 10 years.
And so as part of the cost benefit analysis that you referred to in response to the question by hearing examiner Hurst about if Oracle was a benefit or not, wouldn't one of the in parts of a true investigation be whether or not an MGC should build its capacity to have a cloud-based server, or to have the shared services that it was going to be sold in 10 years.
Objection. Compound, also lack of foundation. This witness has not been qualified in any respect as an expert in IT systems or anything of that nature, and that's what he's being asked to opine on. And there's just no basis in his background to do so.
Madam
Mr.
Hearing
Massey?
Examiner, I'm not asking him to opine about the service. I'm asking him about the investigation that is lacking that you asked him about. You asked him about the Oracle service, and isn't that a benefit? And he said, we have no idea because there hasn't been a cost benefit analysis. And I said, wouldn't one of the things that would be part of a true investigation be whether shared services is better, or whether building the capacity of NMGC is better, given that the BCP is only going to hold it for 10 years anyway?
Mr. Alvidrez?
Yes,
Anything further?
she's asking him about a technical issue with regard to IT services and how to evaluate them. And I think Mr. Sandberg has indicated that he's not particularly sophisticated around computer matters, and doesn't have the qualifications to opine on this.
Well,
Hold on.
yeah, I'm sorry. There's an answer, but I'll keep my mouth shut.
I think that question, I'm going to sustain the objection, Mr. Massey. I think that question is outside the scope. I don't believe he talked about the cost benefit analysis. I think what he said is that his answer to the question was specific to that there were cloud-based alternatives that they should have looked at. So that's the basis for sustaining the objection.
When you were talking about this alternatives analysis, Mr. Sandberg, what were the kinds of things that a true alternatives analysis would encompass?
Well, based on my experience helping several large sophisticated users rip out and replace their ERP systems, including the city of Minneapolis when it bought an Oracle.
Define ERP.
Enterprise Resource Planning. An Oracle system. It's what the city of Minneapolis uses to run the city. And the joy of working with Oracle back then. There were extensive discussions with our technical and management staff about a range of potential ways to replace a creaky old system with new things, new shiny stuff that we had in the server cabinet, new shiny stuff that was someplace else and we were getting it remotely, and new shiny stuff that could be split among and shared by a handful of other larger municipalities. So that cost benefit analysis that they eventually went with Oracle on looked at both the costs and the good stuff about a wide range of potential ways to replace an old creaky system. And Ms. Examiner, when you asked me that question, I didn't mean to say that looking between two cloud-based systems was the only thing one should do. I think it certainly would be part of a careful examination. Both, do we do it in-house? Do we own it? Do we rent it? Do we buy services? But part of that would be, if we're going to look at cloud, we should look at more than one cloud. I didn't mean to be exclusive.
All right, sir, thank you. Ms. Nanasi, anything further?
Nothing further. Thank you so much.
Thank you.
Now, I would like,
we have to go back around. Okay.
Did Nanasi have something to say before I redirect?
You have something before recross?
no, I thought it was over and I was going to
No,
go.
we've only gone once.
And I don't mean
Mr.
to.
Dome?
Yeah.
Madam Examiner, I have no further recross.
Okay. And Mr. Alvidrez,
A couple of questions.
go ahead.
Mr. Sandberg, isn't it true that the People's Natural Gas system to which you referred was installed 6 years ago?
I'm sorry, I'd have to go back and pull up. I don't remember.
And isn't it true?
It has been in place. I know that.
For how long?
I will go see if I can find the answer to your question. Looks like, oh, that's not, okay. That was not the program I wanted to launch. Says here, review. The report I was looking at where SAP bragged about getting People's Natural Gas onto their system was dated May 4th, 2020. So I think that you're right. That's right about 5 years.
Right. And in fact, that's not a cloud-based system, right?
No, that's not correct. It is.
It's the SAP S4 HANA ANA.
Yes, my understanding is that is their cloud-based system.
But SAP doesn't have a cloud-based system until recently, right?
Objection. I believe he's arguing with the witness now.
No. What's the basis for your statement that that is a cloud-based system?
That is the way that when I went to look at SAP, that is the way they described it.
What did they say?
It's their cloud-based solution. I'm sorry. That's all I can tell you.
Can you cite language where it confirms that it's a cloud-based system 6 years ago?
No, I cannot.
Okay. So it's just your understanding that it's a cloud-based system, not based on anything specific that you can tell us about today?
What I saved from my looking around on that question of there's no alternatives to Oracle was the announcement of SAP and People's. I went and looked at SAP. I did not save, so I cannot put up on a screen share pages from SAP. So it is my recollection, but no, the answer to your question is I cannot cite you to it.
So you were asked about the employee protection as one of the benefits by the hearing examiner. And do you recall that she confirmed that the latest commitment is to maintain the current level of workforce for a period of 60 months after closing?
I do.
And do you recall that you responded that you believe that period should be 120 months?
I do.
But isn't it true that you would be satisfied with 36 months?
I don't understand the question.
Yes,
That I would be satisfied. I'm sorry, I don't understand what you mean.
that your belief is that 36-month employee protection, a 36-month period for employee protections workforce is adequate.
I don't know how you're defining adequate. We're not, I mean, this is a balancing question. And if we're trying to maximize some benefits to the transaction, greater employee protection is one way of maximizing some benefits.
Right. And you testified under oath previously that 36 months would satisfy you, right?
You're going to have to point me to something. I do not have that in my head.
Okay, again, you remember being deposed on May 6, 2025, right?
Regrettably, I do.
And on page 32 of your testimony,
Thank you.
beginning at line 14, you were asked this question. What is the basis for the 36-month period that you propose? Line 16 says, A, it's long enough to, again, try to deal with the typical private equity, come in, strip, leave phenomenon. Question on line 18.
Sorry, come in, strip, and
leave phenomenon.
What page are you on, please? I'm sorry.
I'm on page 32 of your deposition.
Give me a sec, please.
Okay.
Get enough context here. Thank you.
And on line 18, the question is posed, okay, if the BCP applicants agree to maintain the current workforce for 36 months post-close, this would satisfy your condition 5, correct? Your answer at line 21 is yes, sir. That's what you testified to, right?
I see it there, and I'm wondering if we were still talking about back on TICO, or if we'd gone forward. But I won't quibble with you. The testimony and the transcript is what it is. I don't think it's correct today. Remember, this was before we had the benefit of all the other interveners coming in with their rebuttal. And I haven't had a chance to think more about it. So yes, I have changed my mind.
And which party has proposed a 10-year period?
I don't know that any party has proposed that explicitly. What I'm trying to say is, given the range of concerns that were raised by every other intervener, and looking to see if and this started with a question about, are there ways you could rebalance or that would help tilt the balance more in favor of finding a benefit? One would be to stretch out the term of retention.
And so we're clear, when you were deposed on May 6, 2025, what was before the commission at that time was the original application, correct?
That's my recollection as well.
And the revised application includes several benefits that were not included in the original application, correct?
I believe the joint applicants have tried to enhance them both in the filing and subsequently. Yes.
Okay. Those are my questions on redirect, Madam Hearing Examiner. Thank you.
Thank you. I don't believe there's any further questions. Mr. Sandberg, thank you very much, sir, for your time today, and I hope you feel better. You're
Thank you for
excused,
that.
sir.
And I apologize for being froggy today.
Thank you, sir. You're excused.
Madam,
Ms. Nanasi, you had something else?
yes, Madam Hearing Examiner. I wanted to just give you three points of law regarding when you decide if New Energy Economy Exhibit 1 can be admitted into evidence. Number one is Rule 11-703, New Mexico rules, annotated. Quote, an expert may base an opinion on facts or data in the case that the expert has been made aware of or personally observed. If experts in the particular field would reasonably rely on those kinds of facts or data in forming an opinion on the subject, they need not be admissible for the opinion to be admitted. But if facts or data would otherwise be inadmissible, the proponent of the opinion may disclose them to the jury only if their probative value in helping the jury evaluate the opinion substantially outweighs their prejudicial effect. And then there's two cases that I call your attention to, Your Honor. One is a 1996 case, and the case is entitled Baerwald, Bearwald versus Flores, Flores, and that's at 930 P2D 816. It's a 1996 case. The other site is 122 NM 679. And this is a quote from that case.
I think, Ms. Nanasi, I think just the citation will be sufficient. Thank you.
Okay. And then I have another case, and that's Furstenberg versus Monribot. Both these cases are about expert reliances on articles. And that site is 350 P3D 1205. It's a 2015 case. It's a New Mexico Court of Appeals case.
Very well. Okay, thank you. Anything further?
No, I just would say that it says that the expert may rely on an article because it is the expert who determines based on study and experience whether the article is reliable, and therefore the article becomes, in effect, the expert's own opinion. Nothing further.
With regard to your reference to Rule 11-703, I realize that that rule refers to the opinion itself, but you're saying that is extended to the allowing an exhibit on which the expert formed that opinion?
It doesn't say that explicitly what you just said. It says an expert may base an opinion on facts or data in the case that the expert has been made aware of or personally observed. And then I can read the rest of it. If experts in the particular—
No, I can read the rest
No,
of
we
it.
can,
And
that's fine, Ms.
no, I
Nanasi.
can read the rest of it. I'm just asking, no one has moved to strike your expert's opinion. There's just a question about whether or not actually attaching the exhibit as an exhibit to his testimony, the article or paper that he based that opinion on. And I'm asking you whether or not you think that Rule 703 allows that.
I think that both under Rule 11-803R and 11-703, which was cited in both in the Beer World versus Flores case, concludes by saying what I said before.
Okay.
And also, I believe it's been the practice in this PRC that unless there's some other objection, that articles that experts rely on in their testimony has always been accepted.
And can you give me any specific case?
Yeah, the 20-00222 UT case. I can,
Okay.
and Mr. Sandberg had lots of exhibits in that case, and I believe all but one part of his testimony that was not about an article was accepted.
Okay. Thank you.
Thank you.
Mr. Alvidrez, any response by you with regard to the legal authority or Mr. Domi that's been proposed?
Madam Hearing Examiner, is my objection.
Okay.
I have not been able to digest all that, Madam Hearing Examiner. Could I have a few hours, like overnight, to look at it, and we can talk about this in the morning?
Sure. Absolutely. But
I'm
not
happy.
in the morning, or you'll be here
Oh.
by yourself.
You're right. How about, okay, let me just have 36 hours, ma'am, and I'll look at this over.
And I can send the sites to all the parties.
I wrote them down, and the transcript will be available. So the parties that should be able to get them, but if you want to email the parties, that's up to you. Not a requirement, Ms. Nanasi. Okay. More homework. Very well. Think thanks, Mr. Zigich, thank him, staff, Mr. Friedman, Ms. Lang, for hanging out, waiting for us. Don't think we're gonna get him today. We've only got about 5 minutes. So I believe if my notes are correct, we have an option. We can go ahead right now. We had planned for NM area, Mr. Walters, then Mr. George, then Mr. Kenny, then Mr. Sabuco, then the CCAE witnesses, then the FEA witness, and then the staff witnesses. Since we already have a lineup for Wednesday morning, is there any reason we need to take staff out of order? So think about that. Ms. Beatles and one other. Ms. Beatles, you raised your hand?
Yes, thank you. We may prefer to offer Sabulco as a witness before Kenny. So let me know if that would be a problem or issue.
I don't have an issue with that.
And I have
I
one more.
just noted, I just put them in order, I think, of how you had them listed. Nope, you had Sabuco first. No, not a problem.
Okay, I have one more
Anything
question.
else?
Yes,
Sure.
I've noticed that the transcript of the hearing is available the very next day. But given that tomorrow is a holiday, we probably won't see today's hearing transcript until Wednesday morning. Is that how it'll probably work?
I find that
Mr.
highly dubious.
Mr.
Okay.
Lee?
It will be
Well, for
it will be
example,
available tomorrow morning.
there you go.
So if it's, but, so first of all, I think it's remarkable that you get them filed the very next day, so I'm not trying to put any additional pressure. But if it is available the next morning and tomorrow's a holiday, is there any way that we can get it?
He's saying it's going to be available tomorrow morning. So if you're working tomorrow like I am, then it won't be a holiday and you can look at it tomorrow.
But the way
I'll
I
make
look
sure
at
you
it,
get it, Miss Beatles. I'll make sure you get it.
thank you, because the way I look at it is an eDocs, and I was just wondering if maybe eDocs won't be entering document. That's
Okay.
why.
Okay, the delivery method. Okay, I didn't get that part.
Okay,
Okay.
it's
All
late.
right.
I was trying to
It
explain it as
is.
clearly as I could.
Okay. All right. And then I don't know who was next. Ms.
Rossi.
Lynch. Mr. Rossi was. Mr. Rossi?
Thank you, Madam Hearing Examiner. For Dr. Zadalis, we'll be trying to have him called either first on, say, Thursday morning or first on Friday morning. That's due to both time zone, and also he has a sick child at the moment, which we're hoping will be better by the end of the week. But just, we may have to try to take him a little bit out of order. Wanted to give you a heads up. Thank you.
Thank you. Also, please convey to your two witnesses, Mr. Rossi, appreciation for them being ready to go, even though they weren't. Can I just put them back in the staff order?
I think that's most reasonable. Thank you.
Thank you. Okay, Ms. Lynch.
Thank you, hearing examiner. I just wanted to remind you that our witness Stephanie Penn is not available on Thursday morning at all from 9 to 12. So she would be available Thursday afternoon, 1 to 4. And our witnesses have been in touch with us, wondering if there's any more certainty about the possibility of when they might be called up.
Well, you can look at the chart as well as I can, Ms. Lynch, and right now, I mean,
I'm not, I can figure it out. I've just
Okay.
told them probably Wednesday afternoon, and then we have that issue on Thursday morning that I
Right,
just shared with you.
Sure, right now, so on Wednesday we start with Mr. Walters, and so depending on if people actually cross for that amount of time, chances are that that'll take up the morning. Potentially, Mr. George is next, so it obviously, if we could get both Mr. George and Mr. Walters done on Wednesday morning, and let's see, then the WRA witnesses, I mean, that's another,
Yeah, so potentially once,
say,
yeah,
early, so very well might be, very well could be later Wednesday afternoon.
Okay.
And if you want to call Dr. Penn first Wednesday afternoon, if she's got a morning problem, we could do that.
Okay, I'll propose that. That sounds
Okay.
good to us.
Okay. I say, if that's how we're going. And otherwise, you probably could put your other two on. And, if we finish with your witnesses, we'll accommodate having Dr. Penn in the afternoon.
Okay. Yeah, just,
Okay.
For communication reasons to them, I just wanted to express the possibility of when they might be called up.
Sure. And like you say, I mean, I'm happy the parties have been very accommodating to deal with other, weddings and sick children and whatever. So, I think we can do all that. And again, as you can see, there's not a whole lot of, I mean, compared to the beginning, there's not a whole lot of, cross-examination, which I find interesting that, the staff and interveners, don't have cross-examination for the other parties, but, uh, be that as it may, really the only cross-examination, save FEA having 20 minutes for Dr. Zadalis, there is, well, and staff has 20 minutes for FEA witness Etheridge. So, and that was actually, yeah. So other than that, all the cross-examination is coming from the joint applicants, and then any questions that the hearing examiners have. So, okay, with that being said, Mr. Alvidres.
Yes, Your Honor, thank you. We do have the issue of the George testimony. We did get this morning, I guess, the marked up version of the testimony, and there was precious little that had been changed based on compared to his original testimony. And I don't know if you want to take that up now or if you want to take it up when he's presented on Wednesday. I'm happy to do it either way.
Can you, are there parts that you think still need to be changed?
I think that very little of that testimony should survive under your order. The order was specifically limited his testimony to regulatory proceedings, and I'm quoting from page 4 of your order, in which he has participated with joint applicants or their affiliates that may be of some relevance to the instant proceeding. Well, the only regulatory proceeding in which Mr. George participated was the New Orleans proceeding involving the Delta Utilities transaction. The rest of his testimony relates to matters unrelated to any proceedings in which he participated. And so we've got just a few really lines that would survive under the terms of your order. And what has been presented really is the only thing that was removed was a footnote and one exhibit, the Louisiana Illuminator exhibit 1 or 2, and then the other exhibits were renumbered, but they have nothing to do with proceedings in which Mr. George was involved. So that is our position, that based on your order, there really is very little, if anything, that Mr. George ought to be allowed to testify to.
Mr. Nasi?
Yes, obviously I thought that we were in compliance with your order. I thought that the only thing that your order said definitively was that the newspaper article was struck, which I took out, and that he could not testify as an expert witness about regulatory proceedings in New Mexico. So, but I didn't think that it was limited to only his his regulatory experience with BCP. I thought that, I mean, clearly his other research into BCP that he, conducted, and also his experience with the current with customers, and them coming to his nonprofit advocacy organization is quite relevant to the experience and goes to one of a couple of the factors that are part of the 6-factor test. So if I had a broad understanding of your ruling, and then there's basically nothing left of his testimony if you're striking it all. But he's an eyewitness and he has firsthand knowledge because he's been in touch with a number of customers of the BCP owned, in addition to his research and background and experience and investigation that he's done into BCP. So I don't understand.
Go back and look at the transcript ruling, Ms. Nanasi. I don't have that particular file with me in front of me. So I don't I'm not suggesting that Mr. Alvidros is misrepresenting the ruling. But to get the specific wording of the ruling, go back and look at the transcript.
I think that you made a written ruling, Madam Hearings Examiner. And it is the order granting in part and denying in part joint applicants' motion in limine to exclude direct testimony of knee witness Jesse George.
I did. That was the beginning. Beginning of the hearing.
Yes, Your Honor, and that's what I was citing to on when I mentioned page 4. It was page 4 of your order.
I mean, explicitly, you said that he's not qualified to be an expert witness, but you said, however, Mr. George has offered other testimony of regulatory proceedings in which he has participated with joint applicants or their affiliates that may be of some relevance to the instant proceeding. Therefore, Mr. George may testify as a lay witness to other regulatory proceedings in which he participated with joint applicants or their affiliates. And so I think that basically everything that is left could fall in under that, including his research, and basically rebuts some of Mr. Baudier's testimony. So that's why.
Well, if you think you've complied with the order and Mr. Alvidros thinks you haven't complied with the order, then I will look at Mr. George's testimony and hearing examiner Schaefer and I will decide whether it's compliant or not.
Thank you.
Okay. I will add that. Okay, very well. Anything further? Seeing no more hands. Thank everyone for their participation today. We are recessed until if you have procedural things to put on the list, 8:45 on Wednesday. We will begin the continuation of the examination of witnesses at 9 o'clock on Wednesday. And thank you very much. And everyone, please remember, there will be no hearing tomorrow. Mr. Lee, thank you very much. And we are recessed.
Thank you,
Thank
everybody.
you. Bye, everyone.